may I be permitted to mention, my lord, seeking leave to file, my lord, written statement commercial suit, my lord,
Huh?
with written statement in commercial suit, my lord, within
When
what?
20 days is over?
No.
When? When it is going to be over? When you receive the receipt?
My lord, in June, my lord, in
June you receive.
June 16. And my lord, what has happened, my lord? Prior to that, it has been affirmed since the plaint already served. June 16, my lord, in 16 June, my lord, the writ of summons was served. My lord, may I leave to?
Affidavit is there.
Yes,
Affirmed.
yes, it is affirmed, my lord. He is coming.
New granted. In filing the department, subject to acceptance.
Yes, my lord. I'm giving.
Let's kindly to mention a matter, your
For
lordship,
notice, my lord, I have mentioned.
for correction, my lord, of your lordship's order. But I will kindly take the order passed by your lordship on 9th September. My lord, there were two judgment debtors, your lordship, State Bank and State of Madhya Pradesh. Lordship remembers. My lord, we have no claim against the State Bank, only the State of Madhya Pradesh. My lord, in paragraph 2, your lordship will take the last line in page 2. Page 2, my lord, the last line, it has gone down as judgment debtors. My lord, it will be specifically judgment debtor number 2, my lord.
Against whom the order was passed?
My lord, the State of Madhya Pradesh.
Then this is clerical already clarified. What is to be done? Who is to be done? What is to be done?
My lord, only in paragraph 2, 3 and 4, judgment debtors has gone down.
Maybe.
Number 2 will be there, your lordship.
Maybe.
I will kindly specify that because we are having a problem in serving the order.
So why let the file affidavit of assets? Yeah, or you delete the name of the State Bank of India. Affidavit.
State Bank of India was a part previously, but the function of the State Bank of India was only to withhold the lien and create the lien on the bank account. State Bank of India has created the lien and has withhold and has performed their part. But we don't have any claim against the State Bank of India. Only the State of Madhya Pradesh is the judgment debtor now, at presently before your lordship. So Malad will kindly clarify it's only judgment debtor number 2.
No. Yeah. Yes.
My lord, may I have your lordship's leave, my lord, to make a request, my lord? I'm mentioning upon notice. My lord, the SX matter your lordship had fixed on the 15th and the 16th. 15th, my lord, seems to be a truncated date. My lord, it's some difficulty in the 15th morning. Could it be on the 16th then, my lord? I'll address your lordship. I'll continue with my arguments. 15th morning is a little difficult. In any case, your lordship has fixed it at 11:30. But I think, my lord, we'll have to, my lord, the court will have to rise a little early on the 15th because of the Chief Justice's farewell.
Okay, okay, mention that we'll say 16.
Very well. Grateful, man.
Your lordship, will it come on the list on 15 then? Will it be listed on?
It will be listed.
Yes.
You're for the other side.
Yeah, I'm for the other side.
Okay, it will be listed, but I will not take the matter. If there is a problem, then 16 it will be taken.
I'm very grateful. 16th is already fixed. Grateful.
My lordship, may I be permitted to mention a matter I'm mentioning upon the notice of the other side. This is a non-commercial matter which is to be taken up in the second half today as item number 34. I'm led by Mr. Choyan Gupta, but he has expressed his difficulties to attend the court today as his father was admitted in the hospital and to be discharged today, my lordship. I'm praying for an adjournment today.
Come at 2. Come at 2. When the matter will be taken, you come at 2. Seek adjournment, I will sit.
Highly obliged, my lordship.
Your lordship, may I be permitted to mention a matter? This matter is a commercial matter for non-payment of invoices. The evidence has for non-payment of invoices. This matter, sir, the evidence has been completed. The arguments have been made. We just need to conclude the arguments. It will hardly take 10 minutes of your lordship. If your lordship would kindly be grateful enough to accommodate any.
It is not in the list.
It is running as item number 110 in the daily list. We would like to request your lordship to fix any day for the conclusion of the final arguments.
Then December. Take instruction from your senior. If you want the date and time, then it will go to the December. If you take the chance, then let it be remain in the list, then it can come. Because one day the court is taking new motion, adjourn motion, then argument, and so you may get the chance. Let it be in the list. If it not, then I will fix the date.
May I have your lordship's kind leave to mention a matter upon notice to the other side. Lordship may recall this matter was taken up by your lordship day before yesterday. Company matter, the company called Bharat Process and Mechanical Engineers, where, my lord, a large portion of the property, company in liquidation, my lord, but a particular tenant, my lord, is occupying the property for only 4,000 rupees a month. So your lordship had been pleased to direct, my lord, to OL to file a report indicating what all steps he has taken so far as eviction is concerned. Now, we have checked just now, the order has not yet been uploaded, perhaps. But, my lord, only praying for one small clarification, my lord. If the order has been passed already, my lord, lordship will kindly list the matter, subject to your lordship's convenience. Let it only be clarified, my lord, that the OL can take steps to evict the particular occupant in the meanwhile. Let them not wait for 2 months to file the report and not take any.
Fix a date for filing a report.
Yes, that is in the end of October, perhaps. So, my lord, in the meanwhile, my lord, if they can, my lord,
Okay.
take steps, that is the only.
I will take. I will see.
This is the matter, my lord. Given the mentioning notice and indicated the matter.
लिस्ट में आया है ये करेक्शन हुआ पता नहीं देख लो एक बार देख को बोलो मत करो बोलो मेरे पास फाइल भेजने के
Grateful, my lord.
Mention a matter, Lordship. This is I'm praying for kindly draw up and complete the order and judgment passed by my Lordship on 31st of July 2025.
Mention a matter. This is a non-commercial matter which has been transferred in commercial matter. I am mentioning this matter for inclusion in the list, my lord.
My lord,
Hello.
my lord, may I pray another indulgence, my lord? The 283 matter, my lord, that has been part and marked, my lord.
What has happened?
My lord, the
Appeal?
division bench, my lord, made it CAB, my lord. And matter is today is appearing, my lord, item 46. My lord, yet.
I don't think it will be taken. If it's taken, I will adjourn them.
Yes, my lord.
Unless the appeal court order is there.
Yes, yes. It may come, my lord, within a week or
Okay, let us.
non-commercial 46. Grateful.
Commercial item number 1. For judgment.
And for the plaintiff.
Considering the above, this court finds the plaintiff is entitled to get an amount of 52,62,725 along with interest at the rate of 15% per annum from 8 January 2019 till the realization. Then I have segregated which amount from which date.
Right. Grateful.
But 15%, not 30%.
Grateful, my lord. My lord, I must say, my lord, 15% also, my lord, we are grateful for that, my lord.
Yes. Next. The same. All are been granted from the
Three. My lord, I have one request, my lord. My lord, there's a matter fixed in the writ court, my lord, for which I have to rush. Item 7, my lord, if it is called in my absence, kindly, my lord, consider granting a passover. My lord, colleague will be there. Grateful.
Yes, call for.
Item number 4.
Lordship, item number 4, I'm appearing on behalf of the defendant.
Sir, I feel very much embarrassed, my lord, to just a minute. That matter comes before your lordship again for the order, my lord. This is all regard being had to the transfer of the Vakalatnama, my lord. My learned junior friend has taken the objection, no objection, and has rectified the same, and I will file the fresh Vakalatnama. Yes, my lord.
No, according to law, census, both it is mentioned that an advocate has not appeared. Why you not appeared in the department?
Lordship, I had I had appeared before the department. There was some miscommunication with the department. The department said you are out of time. There is some difficulty. So instead of harassing the department, also court has prepared a fresh account.
The advocate on record of the defendant?
Yes.
Yes, my lord.
Advocate on record of the defendant, namely, what is the name of advocate on record? Huh? Sanjay Ginodia is liberty to file Vakalatnama and affidavit of competency within a week from date.
My lord, can there be an extension of that we will take? The commissioner is taking the my lord. My lord.
Next.
For the defendant, my lord.
We are for the plaintiff.
Inspection and discovery, my lord, after March deliberation is complete now. So we have to, my lord, frame the issues, my lord. But I am carrying the suggested issues.
My lord, may I file my affidavit
the
of documents and the
affidavit of,
admission and denial
Denials are filed, my lord. You want the-
on behalf of the plaintiff, my lord.
Yes.
After this stage, my lord, we are on issues, my lord.
So what is now stage?
And
Framing
it
of
can be-
issues.
And I am carrying the suggested issues. I have given a
we
copy
haven't
to them.
prepared a suggested issues, but I've had a look through my lord, the defendant's issued. My lord, I don't think all of the issues are necessary. 2 or 3, my lord, I can consent to, my lord, can frame those issues. It's really a suit. My suit is for price of goods sold and delivered with interest.
Hmm.
My learned friend has sought a counterclaim on account of loss and damage on account of some breach of contract.
Hmm.
My lord, can frame those 2 or 3 issues, my lord. I don't stand in the way.
Issues का है?
मैं hand over. এদিকে রাখ। তুই দিলি নাকি কবিতা?
It's a counter claim.
I have a counter claim. I have a counter.
I have a claim of about 60 lakhs and my learned senior friend has a claim of
তোমার claim. তুই তো যাবি।
one tattoo sold. This is not an issue. That's why I admit it.
Who admitted?
Price দিয়েছে material
আমি কিছু admit করিনি।
what my prayer would be
He says he sold this amount of goods. I said I don't admit it. So that becomes an issue. He has to prove it.
the broader
He says it's
issues,
admitted. So
issue numbers 2, 3 and 6 perhaps will cover the entire thing. my lord. Instead of having so many issues framed, 2, 3 and 6 will cover the entire thing.
I think issue number 1, Lord, he has to first, being the plaintiff, Lord, he has to, Lord, prove.
Okay, my lord, I'm sorry, my lord. We also have a suggested issues prepared. I was not. I'm sorry.
দেখ কোনটা কমন দেখো কমন গুলো তো কমন ওয়ান্স উইল গো মিলন হ্যাঁ এটা ঠিক আছে পাঁচটা প্রথমটাই তো কমন সেম হি হ্যাজ অলসো আস্কড ও না আমাদের তো অন্য দিস ইজ দিস ইজ থ্রিটা তো হি ইজ এগ্রিং
3 and 6 I think will cover.
1 and 2 is covered in 3.
3
And then
this get covers in here to interest now ঠিক আছে 3 and 6 are both parties are agreeing Miller.
Huh?
My suggested issue number 3 and 6 both parties are agreeing. But I am also Miller, seeking issue number 1. My suggested issue number 1 Miller.
But one will
Because
be
he has to,
subsumed
as a
by-
plaintiff Miller, he has to prove the delivery of goods. If he's Miller suing me for Miller, price of goods.
Honor will see from the written statement there is no denial of the quantum of goods received. It is a price where there is some balance outstanding, which is an issue. 2, 3 and 6 my lord, of the defendant's suggested issues will cover the entire thing, I believe, my lord. Or my issues, my lord, they're broad enough. We don't need to go into the nitty-gritties.
Your issue number 6.
Yes, 6 he consents.
Correct. Now 6. Now come to 7.
Lord.
Suffered loss. That is not covered here. 6 is
But
covered.
6 is his. My suffering of loss and damages is one thing, and he becoming liable for that is
whether the plaintiff is liable to pay to the defendant,
yes,
or any part thereof on account of loss and profit of the business.
This can be Miller.
So the 7 is overlapping.
This can be Miller. 6 lordship may take 6 Miller.
6
7 may
continue.
yes.
7 I will not take.
Very well.
Defendant is entitled to obtain any relief as paid for in the written statement. ठीक है. Whether relief or relief is entitled. So 8 is over. Then 9 is not necessary.
But in fact, instead of 8, kindly keep 9 because 9 is simpler.
Wait.
Yes, 9 is simpler. 8 is complicated.
So I am taking because CUR has already been
more or less covered. That's why
I am taking 1 to 6 and 9.
My lord, 1, my lord, I don't think is an issue in this suit.
Whether the
2
plaintiff
will
has
cover
sold
it.
and delivered the
He has to prove his quantum of sale.
1 second, my lord. 2 will cover it. If I have supplied the goods, only then will I get the decree of
No. There is a difference, Miller.
No,
He is supplying of goods, and I am saying some of the money that you are saying I am liable to pay and not payable to you. That's a separate issue. But whether he has actually sold those goods to me, that he has to prove, Miller.
Unless and until sold, how he can claim?
Yes.
That is what he has proved.
That
So
is what
that's
I'm
why
saying.
whether the principal amount is 38,63,000.
Yes, that is there. Miller. I'm talking about issue number 1. He is saying issue number 1 is not necessary. I am saying kindly keep it. Kindly keep issue number 1 because as a plaintiff he has to prove it.
Plaintiff has to prove,
Yes.
unless the issue number 1 is not proved, how we can go to the
Correct,
issue number
correct.
2?
That's my submission.
Who is a
Unless
broader
unless issue number 1 is proved, he can't proceed to any other issues thereafter.
My submission is 2 is a broader issue. It will cover issue number 1 as it is, my lord. Unless I prove my case,
One
of
is-
course, I won't get the claim on account of principle. That's all I'm saying.
1 to 6 and 9.
Both the parties have filed the affidavit of admission and denial of the documents. Let the same be kept in the record. The parties have also filed suggested issues. Full stop. After hearing the parties, peruse the pleadings and the suggested issues, some of the following issues are framed. सब इसमें कवर हो गया है, इसमें लिखने की जरूरत नहीं है। 1 2 3 4 5 6 and 9 मतलब ये नहीं आएगा, ठीक है, ये इसमें कवर हो। The judge's brief.
Judge's brief, my lord, will prepare.
Ready?
No, it's not ready, my lord. We'll prepare. My lord will grant us some time. We'll prepare.
You also filed judge's brief.
But he has to
But you disclosed.
I have already disclosed it, taken inspection.
Together, my lord,
If-
we'll
This for time to file judge's brief document.
my lord,
Let the
weeks
judge,
after Puja vacation,
let the judge's brief document be filed within 3 weeks after Puja vacation. Full stop. The plaintiff is also directed to file the examination on affidavit of evidence within 2 weeks thereafter. Full stop. After serving the copy to the learned counsel for the defendant. Full stop. Let the matter give the date 16 December at 2 p.m. for witness exam.
deep level.
Next.
Grateful.
My lord, my affidavit of admission denial has been filed.
My lord, I appear for the petitioner, my lord. This is that order 13A application.
My lord, I am for the defendant
concluded
short
our-
passover, my lord. For 20 minutes, my lord.
Yes, Mr. Lakhani
Yes,
mentioned that. Also.
My lord, I am for the petitioner, my lord.
My lord, I appear for the respondents, my lord.
Yes.
My lord, on the last occasion, on the last week itself, my lord, I was submitting on this. It is about a disclosure of some documents, my lord. That is what is the matter. And not only that, I have described the nature of the documents, I also, on the last occasion, my lord, with deepest of respect, my lord, I said that I will take a chance, your lordships. As a judgment, it falls from your lordship, and then another judgment of the Supreme Court. These two I will describe, because, my lord, my submission was rooted that these documents, although this particular case was filed as an I mean a civil suit, thereafter it was converted to a commercial suit in 24. Thereafter, my lord passed orders on this, and the matter was on the last occasion was fixed, prior to last occasion was fixed for evidence also. And then thereafter, my lord, we have, as per your lordship's order, we have also deposited 50,000 as a cost. Thereafter, my lord, on the last occasion, I have also stated that my client is bleeding because they did not get this amount of money, which is an insurance claim, where a shipment, consignment was going from Assam Silchar to Howrah, and on the mountains, it met with an accident. The entire cargo went into the gorge. So this is all about. Two question arises. First, 6.5 crores was the consignment value, and then since it was the customs product, so another 6.5 crores was payable on account of those taxes and all, if there is a loss. So this is customs procedures. There was a case pending, the last document, there was a case pending, and that has been decided very recently. That documents I am also disclosing. So these are the documents, my lord. One is an invoice which was given with the transporter, and then it was recovered from the consignee itself. Consignee has given a no due certificate that some money was transferred as an advance, which they said that they have got those returned back from the consignor, that is the plaintiff. This is the document. So I have made it on the last occasion also, my lord. I am not wasting much of the time of your lordship, but I'm simply going on this. First is page 3 at the bottom, my lord, is at paragraph 7a. This is a no due certificate given by the consignee. My lord, it was obtained, my lord, has
given.
My lord,
to whom it was given? To
it
you.
was I collected it.
When you are collected?
I collected it very recently, my lord. Now the question remains the documentations. On the last occasion, I told that this documentation, I do not have this documentations. That's why my lord has asked that that should have been reflected, that you have went and then you have received it by your hand. That was the case, my lord. There is a dearth in doing that thing. That has not been done, my lord. But that is the case. And then thereafter also, and second document is page 4, my lord. Officer in charge, regional transport office, my lord. It has been received from the owner of the truck, my lord. Now the submissions of my learned friend was that he is defendant number 2 here, but it is not. They are the not the truck owners. They are the persons who are the private limited company who takes different cars and send them for consignment. So they are not the owner of the truck. I collected it.
Who is not the owner of the truck?
The defendant number 2, because they are the commercial transporters. They are not the owner of the truck. My lord, that would be apparent from the face of the FIR also. Okay. So therefore, the owner of the truck, I tried investigating who is the owner of the truck, from whom I have obtained this very recently. What is the document? What is the mail correspondence? My lord knows it better, my lord. Customary also. This owner of the truck, they are not that savvy with the mails and all letters and all. They hardly sign something. So I obtain it from them, my lord. This I have never stated that the way I have taken it by hand. This is number 2. Third is an account pay check which was received by the owner of the truck from the insurer of that truck for its total damage. This is another insurance company, that is Bajaj Alliance. That would be reflected in that. That has also been obtained, that they have given this money for the total loss of the car, because they have also doubted the accident. So that's why there was an accident, although apart from the charge sheet and the FIR given by the police authority. And the fourth is that tax invoice come, excise invoice of showing the packets of supari sent to the consignee, that was with the consignee. He is not a party to this proceeding. These are the document I collected, my lord. So last I was telling about the document E. This is a 5th document. That was the Custom and Excise Service Tax Appellate Tribunal order, that this amount of money has been returned back and they are not supposed to give this money, and they have paid this money. That has also been reflected in that said judgment. These are the documents, my lord, I like to disclose subject to your lordship's permission. Now, my lord, I will rely on this to a judgment of Honorable Apex Court first. My lord, this is a very known. I will simply give you the judgment also. Show me another judgment. Give me another copy. My lord, this is Sudhir Kumar alias S. Balian versus Vinay Kumar GB. My lord has taken reference of this case, and my lord has passed catenary of judgments on this, both declining the petition and also accepting the petition. So, my lord, this particular judgment there itself has, Supreme Court has told a lot of things, the provisions of the law, this and that. And then thereafter, my lord, it gives, the Supreme Court says it is the discretion of the court to finally arrive at a conclusion that whether the documents will be permitted to be produced. That is the thing. So it is there. Thereafter, my lord, if your lordships allows me, just give me a moment's time, my lord. একটা ইয়েটা দাও ওই জাজের সুপ্রিম কোর্টের কপিটা কোথায় গেল সুপ্রিম কোর্টের কপি নো আই হ্যাভ নট গিভেন একটা কোনো কপি দিইনি আর কপি কোথায় হয় আছে দাও এটা দাও মুখে তো একটা
Yes.
My lord, I am not going to the details of the judgment. My lord has discussed, because I will next thereafter I will show your lordships. It has fallen from your lordships. So there it has been discussed at length. My lord, unfortunately, at that particular case, I was for the defendant. It has it was accepted by the honorable court. Now that this particular judgment, my lord, has referred in this the matter of Glen Industries, there my lord has taken that paragraph also. Now I would like to only read that paragraph. Paragraph 10.4. Last two pages, my lord. My lord got it. Now, so far as the other documents sought to be relied or produced as additional documents other than the invoices are concerned, the same stands on different footing. It is not disputed, and in fact, it was not specifically admitted. And so stated in the application that those additional documents other than those invoices were in possession but not produced, being voluminous, and that the suit was filed urgently. However, it is to be noted that when the second suit was filed, it cannot be said to be an urgent filing on the suit for injunction, as the first suit was filed in the month of October 2018, and there was an ex parte ad interim injunction by order dated 29/10/2018, and thereafter the plaintiff withdrew the said first suit on 27/7/2019 with liberty to file afresh as per the Commercial Codes Act, and the second suit came to be filed on 31st August 2019 after a period of 1 month from the withdrawal of the first suit. Thereafter, the case on behalf of the plaintiff that when the suit was filed, it was urgently filed. Therefore, the additional documents sought to be relied upon other than the invoices were filed in the same, where voluminous cannot be accepted, and therefore, as such, the Order 11 Rule 1(4) shall not be applicable. Though the application was filed within the 30 days of filing of the second suit, while seeking leave of the court to rely on the documents which were in their power and possession, control and custody, and not disclosed along with the plaintiff, and within the extended period set out in the plaintiff has to establish the reasonable cause for non-disclosure along with the plaintiff. This is the reasonable clause, and that the discretion is with the honorable court. In view of the facts and circumstances narrated herein, and in view of filing of the first suit, the ex parte ad interim injunction order in favor of the plaintiff dated withdrawal of the first suit and subsequently the filing of the second suit, non-filing of the additional documents other than those on the invoices on the ground of they became voluminous cannot be said to be a reasonable cause for non-disclosure filing along with the plaintiff. There was a sufficient time gap between the filing of the first suit and filing of the second suit, approximately 10 months, and therefore, when the second suit was filed, the plaintiff was having sufficient time after filing of the first suit to file the additional documents other than the invoices at the time when the second suit was filed. Therefore, as such, both the courts below have rightly not permitted the plaintiff to rely upon the documents other than the invoices as additional documents in exercise of the powers under Order 11, Rule 14, read with Order 11, Rule 15. In view of the above and for the reasons stated above, plaintiff can be permitted to rely on documents in form of invoices as mentioned in the application as additional documents. However, such production shall not affect the outcome of the interim injunction application submitted under Order 39, Rule 1 of CPC, which as such is reported to be kept for order. In view of the above, for the reasons stated above, the present appeal is partly allowed, my lord. I will not go to this further. Now, my lord, I will try my luck with the second judgment. This was, my lord, 2024 SCC online. Give a copy. Calcutta 6803. My lord, this has fallen from your lordship. This is Glen Industries Private Limited versus United India Insurance Company Limited. My lord, I will go to the exact area. It starts from page 3, my lord. Order 11 has been described. Heard the learned counsel of the parties. My lord, there it starts from chapter 10. But if your lordships kindly sees what was the ground for not disclosing. If your lordship kindly takes up the first page, my lord, the plaintiff has filed the present application seeking leave to disclose some documents which were not disclosed with the plaintiff at the time of filing of the plaint. On receipt of the writ of summons, the defendant entered appearance and had filed written statement. After filing of written statement, the plaintiff has sent an email to the defendant for inspection of the documents, and in reply, the defendant has informed the plaintiff that the defendant will inspect the documents on reopening of the court after puja vacation by an email dated this, and the defendant has informed the plaintiff that the defendant will inspect documents on this, and in reply, the said email, well, these are to disclose further documents. Mr. Subhashish Sengupta, learned advocate representing the plaintiff, submits at the time of preparation of list of documents which was to be offered to the defendant for inspection, the plaintiff has noticed that several documents, my lord, were not filed along with the plaint. He submits that a few of the emails were annexed with the plaint, but the documents mentioned in the said email were not annexed with the plaint. Mr. Sengupta submit that the plaint was affirmed of 20th April 2023. The same was filed before this court on 2nd May 2023. The same day, due to some urgent work, one of the directors had to leave for Germany and had returned to Kolkata on 12th May 2023, due to which the documents could not be annexed with the plaint. He submits that the documents were referred in the pleading, but the same were not annexed with the plaint. But in this case, the earlier lawyers, bunch of lawyers, there is a complete change of gears. A separate set of lawyers were formed. Mr. Sengupta submitted the plaintiff has handed over the documents to its staff for transmitting to the learned advocate for the plaintiff, but due to inadvertence, the same was not handed over to the learned advocate, due to which the same could not be incorporated. He submits that the documents which the plaintiff is intending to disclose, the said documents are necessary for proper adjudication of the suit. My lord, now comes my submissions. Per contra, Mr. Shomendranath Ganguly, learned counsel for the defendant, submitted that the plaintiff has filed the plaint supported by the verification and statement of truth as applicable to the commercial suit, and declared on oath that all documents in the power, possession, control, custody pertaining to the facts and circumstances of the suit have been disclosed, and copies thereof are annexed with the plaint, and the plaintiff does not have any other documents in its power, possession, control, and custody. Thus, at this stage, the plaintiff shall not be allowed to disclose additional documents. But this is the statutory defense, as they have also taken. Mr. Ganguly submitted that it is an admitted case of the plaintiff that the documents which the plaintiff is intending.
Come to the 14.
My lord?
14. Paragraph 14.
All right, my lord. Yes. In the present case, it is the admitted case of plaintiff that the documents were in possession of the plaintiff at the time of filing of the suit and were not annexed or disclosed. In my case, it is not in the possession. The plaint was affirmed on 20th April 2023. Same was filed before the court on 2nd May 2023. On the same day, one of the director of the plaintiff had to leave for Germany for some urgent business commitment and return to Kolkata on 12th May 2023. It is also the case of the plaintiff. The plaintiff has handed over the documents to one of its employee for transmitting the documents to the learned advocate, but due to inadvertence, the same was not handed over to the learned advocate. The plaintiff initially issued an email to the defendant for inspection of the documents. At the time of preparing list of documents for inspection, the counsel of the plaintiff came to know that several documents have not filed along with the plaintiff, and immediately the plaintiff informed the counsel for the defendant that the defendant will take appropriate steps for bringing additional documents on record. But in that case also, I just take a reference. The case was fixed for evidence. From there, it goes back. This was the situation there also.
Where?
In this case.
No, in this case, the case was for the inspection of the document. And what is the case of, in this case, your case?
My lord, so far I can recall, subject to correction, there also it was ready because the JBD, the judge's brief of documents, were also filed. And
that's correct.
Then there, the additional judges.
No, the case arose, you have issued a notice for inspection. Initially, they take
Yes.
stand.
Yes.
It will be inspected after the puja
Yes,
vacation.
yes.
Subsequently, they came to the document and they inform you that they will take appropriate steps for additional document. Then they find an application. So the inspection was not come. Might be, I don't know. As per this
My lord,
fact.
my lord.
And kindly last paragraph, kindly the 16.
Yes, that is the initial stage, my lord. Initial means that was
What is the stage here?
Only the. I have not started the evidence.
Evidence not
No.
inspection completed.
Yes.
JBD filed.
Yes. Yes. There also the JBD was filed.
Okay. Okay. Next.
I also prayed
another matter. Another, what is the judgment?
My lord, I will only go with these two judgments. Okay. One is Balian and another. Okay. These two. Because I on very respectfully submitted on the first day that I will try my luck, my lord. Because this is a case of a loss of the insurance claim. So therefore, I will try it.
Thank you.
Other than that, I will not go for any other statements or submissions because.
Okay. Yes.
Lordship. I'm not submitting on this chapters, statutory chapters, because that is all there in the judgment itself.
As your lordship had pointed out on the first day itself, there is no pleading in his application as to when he had applied to the person, the third party, for the production of these documents. He has not produced those letters. Normally, my lord, what happens with your vast experience in suits, your lordship knows more than anybody else, that even if we have a Xerox copy or an office copy with us, we disclose that. And during the trial, when we give the document to the witness, if any objection is taken as to why it's a copy, then we call upon the other side, or we get the court to issue a subpoena to the third party to produce that original. In this case, these documents on the last occasion, there is no pleading. On the last occasion, he submitted that the photocopies were with them, but they were not disclosed. Now, the thing is, that case is not made out in the petition. Your lordship will see that in paragraphs 8,
But
yes,
only one point.
sir. You have
Photocopies were not with us. We never said.
That was a submission made from the bar.
No.
Very well. Let us go by the petition itself. Kindly takes up paragraph 8. The previous paragraph 8, page 4.
Yes.
These are the documents were obtained lately at page 5, third line from the top, and the copy of the account pay check were obtained lately. The date even is not mentioned. When he had written to that third party to produce those documents, those letters are not disclosed. And another interesting observation was made by your lordship on the last occasion. This document at page 7, This letter of Vishal Distributors, date is 2016, but when he received this document today, I can manufacture a document of 1820. When he received this document, where are the envelope? By hand delivery, it was submitted.
Yes.
If he wants to make out a case, there must be some viable basis for that.
Yes.
And now, my lord, with the newly enacted Commercial Courts Act, Lordship knows there's a time frame. Apart from that, this was a suit of 2014. It's not that it was filed in post haste. There are provisions in the Commercial Act that if it could not be done under 30 days time can be granted from the court. This is a suit of 2014. Since 2014 to 2025, nothing transpired. He did nothing. When it was transferred and renumbered as a commercial suit in 2024, the numbering is of 2025, it was transferred in 2024. Then
24. This is an application.
Doesn't matter. Then he makes that application that it struck them when preparing the affidavit of evidence. So before that, it was not in the mind. So it is clearly done on lawyer's advice. Any person having whatever documents normally discloses. It's not that whatever documents we disclose, we rely on them. Your Lordship has seen the exhibits may be 10 or 20, but the documents disclosed are maybe 50. So if they were there, this would have been disclosed much before. They didn't even write. Nothing is disclosed. When they wrote to the third party for disclosing of these documents, it's absolutely bold allegations.
Yes.
Suit is long pending documents which go deep into the root.
And the pleading in paragraph 9, that's clearly an afterthought. I humbly submit that although the suit is long pending, but certain documents which go deep into the root of adjudication as referred to above in paragraph 6 are highly required to prove the case of the petitioner. It's clearly an afterthought. And this judgment that was cited by Glen Industries, কোনটা দেখেছে বলো?
10-11 দেখাচ্ছিল, but সে বলল 14, 15, 16 or 14.
Yes, I'm told that this judgment has been cited and yes, in paragraph 15, the plaintiff initially issued an email to the defendant for inspection of documents. At the time of preparing the list of documents for inspection, the counsel for the plaintiff came to know that several documents have not been filed along with the plaintiff, and immediately the plaintiff informed. So there was an immediate action, there was a notice to produce. In the factual matrix of the two cases are totally different. He has not even disclosed one single solitary letter addressed to the third parties for production of these documents. So obviously, my lord, this case has no application. So my humble submission, my lord, is that the application should be dismissed and so should be allowed to proceed as it was.
Yes.
Well, Lord, I leave it to your lordship because there is nothing more to add.
Statement.
And just another letter, my junior points out that page number
Annexure D.
Annexure D. That is the
D.
Yes, the Road Kings Private Limited, some challan is here. This Road Kings is defendant number 2.
Statement of truth and list of documents under order 11. Yes.
Pagination 10, 14, 11, 12, 13, 14.
14.
Page 14.
Road King, yes.
Yes. This Road Kings Private Limited, that is the defendant number 2. So, notice to produce could have been given any time.
Who is appearing for 2?
My lord, somebody is appearing.
Somebody had appeared and prayed for affidavits.
My lord, I have stated that they are the transport company, but they are not the owner of the truck. One is appearing, one person.
And for the national insurance.
You are not called the statement of truth and affidavit of
My lord,
document
if
after
your
the
lordship
transfer of the
kindly
suit?
look to the
Give the
order
written
dated. I'm so sorry, it's triple, my lord, but yet 23rd August 2023 passed by your lordship.
2020.
Those were filed, my lord, but thereafter
It's a statement of truth. It was filed on 26th April 2023. That's the date of affirmation.
इसके बाद statement truth चालू का है. You have not taken any steps for comply with the commercial court act after the transfer of the suit.
Yes, yes.
Where is what steps?
My lord, we have also supplied the copy.
Where, that's why I'm asking.
And
where
thereafter, after the passing of the order by your lordships, the courtroom was changed to 40 to 41. I think your lordships. And there, my lord has asked for an order from the, one observations report from the department itself.
Who is Manoj Kumar Jain?
Manoj Kumar Jain is the plaintiff, my lord.
Plaintiff.
Representing one of the partners of.
So where is your affidavit of document? And where is the statement of truth? Plaintiff report आया क्या? देखो उसमें पहले कोई report है? Office का in terms of order dated 23rd August. 23rd अगस्त के बाद वो कब का है?
की पूरे डॉक्यूमेंट चाहिए.
You plaintiff has also not filed statement of truth and list of documents as per the Commercial Court Act under Order 11.
I'm for the defendant number 1.
I'm for the plaintiff.
Where is your affidavit of truth and all? Because there is a report, because 23rd of August 2023, this court has passed an order.
Yes.
So you have taken time. Then court has filed called for the office report.
My lord, we have submitted in that we have filed the same.
That's why wherein that is office report is there. There is no statement of truth and affidavit of documents in terms of the Commercial Court Act. You see this report.
This is the copy I'm having.
See the report.
See
the report of the office.
Lord, can I take an inspection, my lord?
I am showing that. That's why this.
Lord, this is the copy I do have.
Give here, Madhu.
September 20.
It is 26th April. Kindly see the report. What is the date of the report?
18 September 2020.
Not available.
My lord,
Might
then
I
will take out one application, my lord.
For what?
For permitting me to file, my lord. If it is so, my lord.
No, why I am telling, otherwise it will be difficult in the judgment.
Yes. That's what I am saying.
Judgment.
My lord, I will take out one application.
What application you will?
My lord, for granting me this leave, my lord.
2023. The plaintiff appeals.
My lord, this is, my lord, your lordships knows, my lord, this is a curable defect if it is so, my lord.
No, that's why I'm pointing.
Yes, I will take out. I will take out an application, my lord. Kindly allows, my lord.
And Mr. Datto,
my lord,
if the case is transferred from the non-commercial division to the commercial division, then the plaintiff will get an opportunity, both the party will get an opportunity, because in the non-commercial division not required to file the document. It list is enough, even list is not enough at the time of hearing, because as per the origin side rules. But and here if the case is transferred from the non-commercial to commercial, and this court has granted time liberty, though the statement of truth is not there, what would be the effect on that?
See, he must make out a plausible case. Had there been letters disclosed by him in this application, I have written to him repeatedly. He has not produced. Those letters should have been disclosed. then
That's correct. That is correct. No,
then the procedure would have
on
been-
merit. Now, with regard to the I am on the procedure aspect. What would be effective?
I don't think, my lord, at this stage these documents can be allowed to be produced.
Okay. The plaintiff has filed the present application being GA Com 7 of 2025, praying for leave to disclose additional documents. Counsel for the plaintiff submits that initially the suit was filed in the non-commercial division, and subsequently on promulgation of Commercial Code Act 2015 by an order dated 28th of March 2023, the case was transferred to the to this court as commercial suit, and the suit was renumbered as CS Com number 58 of 2022. The plaintiff says that the plaintiff could not file the notice certificate received from the consignee, and the plaintiff said that the following document the plaintiff could not file in the present suit, which is very much necessary for the purpose of adjudication of the present suit. Paragraph 7 का A है ना, A to E, ठीक है, A to full stop. Page number 4 and 5, नहीं 3 and 4, small a to small e. Plaintiff submits that the defendant number 2 is not the owner of the vehicle in question in which the goods of the plaintiff were transported. Subsequently the plaintiff came to know, and it is not the transporter. Who is the plaintiff now? Defendant number 2
is a commercial transporter. Two is the transporter. Transporter means
okay.
But that is a company.
Okay. Defendant number 2 bola na, not a owner, is the transporter company who has engaged the truck in which the plaintiff has booked the consignment for transportation. He submits that unfortunately the said vehicle met with an accident and fell down in the gorge. Due to which the material could not be transported, and it has also not been recovered. The plaintiff submits that the documents which the plaintiff is relying upon is very much necessary for the purpose of adjudication of the present suit, and if the plaintiff is not allowed to disclose the said document, the case of and the plaintiff will be badly prejudiced. The plaintiff has relied upon the judgment in the case of Sudhir Kumar alias S. Balyan versus Vinay Kumar GB, reported in 2021, volume 13, HCC 71, and submits that in the said case also the Honorable Supreme Court has held that if the parties shown the reasonable cause, the court has a discretionary power to allow the party to disclose the additional document which was not disclosed initially at the time of filing of the suit or at the time of filing of the written statement. Mr. Ganguly, an advocate appearing for the defendant plaintiff, has further relied upon the judgment in the case of GLEN Industries Private Limited versus United India Insurance Company Limited, reported in 2024 SCC Online Calcutta 6803 passed by this court, and submit that in the said case also this court was of the view that the party has shown the reasonable cause for not disclosing the document and not disclosing document at the time of filing of the suit, and this court has allowed the said application. He submitted the case of the plaintiff is also squarely applicable. The judgment relied by the plaintiff is also squarely applicable in the case of the plaintiff, as the plaintiff has already stated that the plaintiff has booked the consignment for transportation of the vehicle, but the vehicle was met with an accident and fell down in the gorge, and the defendant number 2 is not the owner of the vehicle. Subsequently, the plaintiff has got the documents and intend to disclose the same in the present suit, as the said documents are very much necessary for proper adjudication of the case. Per contra, an advocate Mr. Devajit Datto, an advocate appearing for the senior advocate appearing for the defendant, submits that though the defendant intend to disclose 5 documents which were not disclosed at the time of filing of the complaint. He further submit that it is the case of the plaintiff that the plaintiff when the plaintiff came to know about the said documents, the plaintiff has requested the owner and the concerned authorities for providing the documents, and the plaintiff has got the said document. Subsequently, the plaintiff has filed the present application, but the plaintiff has not disclosed any of the letters which the plaintiff has requested the concerned persons or the authority for providing the document. Mr. Datta further submit that the plaintiff has not shown any reason in the present application why the plaintiff has not disclosed the said document. And Mr. Datta further submits that the suit was filed in the year 2014. Now, after the period of 11 years, the plaintiff came before this court with this present application for disclosure of the evidence, disclosure of the additional document, which is not permissible in terms of the Commercial Court Act, in terms of Order 11 of the Code of Civil Procedure, which was amended under the Commercial Court Act. Mr. Datta submit that the judgment relied by the plaintiff is distinguishable from the facts of the present case. He submits that in both the cases, the court has satisfied that the parties court has satisfied that the reasonable cause has been shown by the parties, and accordingly the Honorable Court has granted leave to the parties for disclosure of the additional document. But in the present case, no pleading to show that the plaintiff has shown any cause for non-disclosure of the said document. It pays for rejection of the present document. Had the learned counsels of the parties peruse the materials of the court. The document which the plaintiff intends to bring on record is of 2016, issued by the one of the document which the plaintiff intend to bring on record is of 2016, issued by the owner of the truck. Exhibit A, Annexer A, who has issued this?
Consignee, my lord.
Consignee, issued by the consignee. The second document has issued by the authority with regard to the accident report of the said vehicle. The third document is with regard to the insurance of the vehicle. Insurance of the vehicle?
Yes.
Insurance of the vehicle.
Which made the accident.
Vehicle in question. Vehicle in which the goods of the plaintiff was transported and met with an accident. And accordingly, the insurance company has awarded an amount of rupees 9 lakhs. 9 lakhs?
Yes.
9 lakhs to the owner of the vehicle. The fourth document is with regard to the intimation regarding dispatch of the consignment of the plaintiff to the consignee. The fifth document is the invoices of the defendant number 2. The sixth document is the order passed by the Excise and Service Tax Appellate Tribunal, wherein the tribunal has passed an award.
Yes, my lord.
Passed an award in favor of whom?
In favor of the plaintiff.
In favor of the plaintiff?
Yes.
In favor of the plaintiff. Dated?
Now not seeking to disclose this anymore.
No, it's there. I have prayed for that.
Dated 30th June. And what is the date of the order?
Last time he submitted his note.
What is the date of the order?
My lord, the
second.
It was originated in 2000.
Dated 4th September 2020.
September 2020. That makes
2020. It is a specific case of the plaintiff that the vehicle in which the consignment of the plaintiff was transported to the consignee met with an accident. But the document which the document number 1, that is the certificate issued by the consignee, namely Vishal Distributor, of February 2016. And the plaintiff has filed the present suit in the year 2014. That is with 2014. That is after the filing of the suit. Considering the above, this court at the time of deciding whether the party can be allowed to disclose the document, this court cannot ascertain with regard to the genuinity of the document. The plaintiff has to prove us a document during the trial. On the face of the record, it is found that this document is of after the filing of the suit. Accordingly, the document number 1, that is the certificate issued by Vishal Distributor, dated 4th February 2016, is allowed to be disclosed in the present case. As regard the second document, that is the accident report supplied by the Superintendent of Police, Jantia Hills District, Jovai, to the Bajaj Alliance Insurance Company Limited, dated 22nd of January 2011, which contains the accidental report of the vehicle and the payment made by the insurance company to the owner. owner of rupees 9 lakh by way of check. Though this document, full stop, this court find that these documents are prior to filing of the suit. The plaintiff has not made any averment with regard to this document in the plaint. The plaintiff has also not disclosed how this document has come in the hand of the plaintiff and when the plaintiff has applied for the said document. Only the averment made by the plaintiff that this document is necessary for the purpose of adjudication. Considering the adjudication, thus this court find that the plaintiff has not shown any reasonable cause why the plaintiff has not disclosed the said document at the time of filing of the suit, because it is not the case that document is not with the plaintiff, and the plaintiff has also not disclosed any reason, any reason when the plaintiff has received this document and from whom the plaintiff has received the said document. Accordingly, this court is not allowed the plaintiff to disclose the said document. As regard the document number 3, which is with regard to the intimation regarding dispatch of 706 cantons of sweet supari powder through the Road King Private Limited and addressed to one Vishal distributor who is the consignee and issued by one Vardhaman Products. This letter is of 29/12/2010. Admittedly, this is the document prior to filing of the suit. This document is not addressed to the plaintiff. This document is the interstate document between two private parties. The plaintiff has not disclosed how the plaintiff.
This document was not, it was authored by the plaintiff, but not addressed to the different.
Vardhaman is the plaintiff. Acha. This document is third party. This document is between the plaintiff and the consignee, admitted consignee. So, it presumed that this letter was written by the plaintiff to the consignee on 29/12/2010. But the plaintiff has not disclosed the said document at the time of filing of the suit. And the plaintiff has not shown any reason why this document has not been disclosed. Accordingly, this court is not inclined to allow the plaintiff to disclose this said document. As regard the document number 5. Document number. This is a Road King. What is this consignee note? Which document it is?
Well, this is a part of the JBD already. This is a part of the JBD. It was disclosed, but the later accompanying this were not
consignee. This is already there.
Yes, it was
only letter you are not disclosed.
No, the letter I didn't disclose.
And
in fact, my lord, that is the consignee copy, not the consignment copy.
But you have referred to. No. Here letter here given to mentioning all the consignment.
Yes. And it goes with the letter because a bunch of documents.
So this letter you issued on 29/12/2010, that was with you, because if you go to the transporter,
the original goes to the consignee.
Original go to the Xerox will be there. If you go to the transporter for transportation of any
it is
goods.
there.
So this copy will be there. The original is
our copy, our office copy is there.
So you're not okay. The document number 5. The document number 5. You are not wanted to disclose this.
No,
5?
Because it is this document also the consigner
appellate order.
My lord, I'm pressing this also
The
because all are getting
the
out
defendant
to
also
the-
intend to disclose the order passed in exercise appeal number 76342 of 2014 dated 4th September 2024. This court finds that this is the order passed by the tribunal excise authority, excise appellate authority on 4th of September 2024, that is after the order passed by this court, and this is the order of the tribunal. Accordingly, this court is of the view that this order can be allowed to disclose by the plaintiff.
But he has not stated when he has got this. That's the whole
But
problem.
date is there. Date of the order is there. Considering the
Announced on 4th of September 2024.
24. That's why after the filing of the suit, considering the above, considering and full stop in view of the above, the plaintiff is only allowed to disclose the document number, the document mentioned in paragraph 7 within bracket A and E. A and E. The rest documents are not been has not allowed to disclose in the present application.
My lord, one indulgence, my lord. An application I may given, I will take out one application.
In view of the above, GA and full stop GA Com 7 of 2025 disposed. Yes.
I will take out one applications, my lord.
What?
For if this is not there, although as to our
You take steps.
I will take because my lord, if
any-
your lordships fix the matter again for the evidence, and then thereafter during this process, if it comes,
the plaintiff is directed to file the supplementary list of documents by supplying the copy of the same to the defendant within 2 weeks from
2 weeks.
Full stop. The plaintiff is also directed to disclose the original document to the defendant for inspection within a week thereafter. Full stop. After the completion of the inspection, the plaintiff is directed to file the judge's brief of document,
Additional judge's
affidavit of admission and denial of the document, and judge's brief of document within 2 weeks thereafter.
my lord, 2 weeks, then there will be vacation.
2 weeks after the puja vacation. 2 weeks after the puja vacation. Please the matter on 26th of November 2025.
My lord.
Your lordship has allowed this letter of 2016.
Yes.
But he has not written one single letter asking for
That's
that.
why he has let it prove. Let it prove in the evidence.
Gratefully, your lordship.
At least he has got something.
Lord, item number 9, my lord, I appear for my lord the petitioner. Lord, my application for my lord substitution, where my lord your lordship had my lord, heard us. This is with regard to my lord the legal heirs of the partnership being brought in. My lord, we had my lord said that my lord there are my lord separate prayers against my lord the other legal heirs, where we have my lord claimed relief in the suit. My lord, Mr. Ghosh has my lord for one of the legal heirs has completed his submissions. My lord, Mr. Moina Bose was my lord making his submissions, but was perhaps my lord, it's been quite some time that my lord, Mr. Bose hasn't made submission. So I believe my lord they'll be in a better position.
He was making it.
And Mr. Moina Bose is making the submission.
Yes, but he has not concluded it, Your Lordship. He has to distinct the judgments which has been relied upon by the plaintiff, Your Lordship. Unfortunately, last evening he had to fly to Delhi, Your Lordship. Even we were not aware, even we were not aware about it. We came to know about it in the morning, Your Lordship. He's not in the courtroom. We even requested him if he can appear virtually, Your Lordship.
When he will available?
Next week he's available, Your Lordship.
1 week he will complete Delhi too.
I have no idea, Lordship. Even we requested him to appear virtually, but unfortunately he couldn't.
Next week, my lord, then that event.
As per the prayer made by the counsel for the defendant 2. Let the matter appear. On 16/7. 16 September.
Oblige, Your Lordship.
Yes, next.
Grateful, but
9-10 action.
for the plaintiff in the matter, my lord. The applicant.
ঠিকই তো আছে।
No, I2, my lord.
Lord, I2 is my petition, my lord. I appear for the defendant. We had concluded submissions, my lord. That was on maintainability and revocation of leave under 12A.
Yes.
The respondents were supposed to make submissions.
My lord, I'm led by Mr. Gupta, my lord, but I will, my lord, endeavor to make very brief submissions, my lord.
Wait, Mr. Gupta is not able to come
Yes,
today.
my lord.
No?
I will not be able to complete, my lord. Definitely. Right. My lord, then if it commences after vacation, my lord, if it commences.
Kindly, Lordship has heard it substantially, my lord. Kindly makes it not today.
As per the prayer made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 18th September.
11, my lord, I appear for, my lord.
My lord, I appear for the plaintiff in the matter as well, my lord.
Defendant, my lord, I was on my legs, but Lordship must have, my lord, till now, my lord, has everything. I do not know, Lordship has extra.
Yeah, hey.
I think Mr. Gupta should start again and
Gupta is
immediately
not.
I should.
Here also Gupta is there.
Yes, ma'am.
Yes, my lord, I appear for the plaintiff.
He should, my lord, make it because it's long time, my lord. He has, because twice he was not there. I'll, my lord, have prepared a note. I'll give that note. Without order 38, rule 5 case is not there, my lord.
Let the matter appear on 19th September.
I'm grateful, my lord.
Yes, next.
I oppose this application. It's an application under the Mr. Dutt's application for disclosure of additional documents.
Appears, my lord, order 11 is taking a lot of time in your lordship's court, my lord. My lord, here the facts are a little different from the previous one. Here, my lord, what had happened is this. Plaint and written statement were filed well within time. After 2 years, the plaintiff files an application that I need to disclose further documents. And, my lord, I opposed it tooth and nail, my lord, but the court said that no, for ends of justice, so far as some documents were in his possession, he could not bring it, allow it. So far as the one which he now wants to rely, I am also allowing it because in any event he can bring it by way of evidence. And at the end he said, for ends of justice, if I am to decide, and I know there are documents which are there not on record, I cannot half-heartedly decide. So I should be satisfied, the court should be satisfied that each party has been given the fullest opportunity to exhaust themselves. So, my lord, on that basis, it was allowed. Now, my lord, when these documents came, my lord, we thought that on the basis of these documents, initially when these documents were filed, it's a suit for damages. Nothing was disclosed except the 2 contracts. Now, the contracts do not speak for damages. The damages will speak on the performance. Now, initially when the suit was filed, my lord, he only annexed the 2 contracts trying to show, my lord, that this is a suit for damages and I have suffered. It's not that Tata Shingur project. He is one of those persons, my lord, who was supposed to set up, my lord, an ancillary project within the area given to Tata for setting up the Shingur plant. Now, your lordship knows, my lord, disputes arose between Shingur and the government or WBITC, who was, my lord, the authorizing body. And, my lord, it went up to the Apex Court. And the Apex Court, my lord, set aside the entire acquisition at all. So, pursuant to that, my learned friend says that I was supposed to get some land. I have made these expenses. So, on the basis of these expenses, you, the state of West Bengal, compensate me. I have filed my statement. Now, when he brings on record these documents, pursuant to the order of court, my lord, I find it necessary for me to further disclose further documents. What are the further documents? The further documents are the stands taken by Tata and the state of West Bengal in the litigation which is going on between them. Because they would be relevant because his cause of action arises from that contract. So I beg to disclose those documents and I offer for inspection. Yes, I was out of time because your lordship had extended the time from time to time, given me penultimate warnings that if you don't do it, I'll close it. But ultimately, your lordship was kind enough to allow us. Now, when I disclose these documents, he says that I will not take inspection of those documents because of the very simple reason you have not annexed this in your written statement. Now, to that, my answer in one line is that these documents have become relevant because you have brought in documents subsequently after 2 years. If you don't rely on those documents which you have brought in after 2 years, then don't allow these documents. But if you have brought in documents to embolden your case, make out a case which did not make it initially, then I must also get a chance to reply and rebut it. So, Milord, there where it stands, Milord, and now, Milord, your lordship will have to decide whether it is a reasonable cause for me to bring in those documents. These documents which I am trying to rely are all common documents. They are documents pertaining to pleadings and proceedings, which I, Milord, in my respectful submission, believe would have some relevance in regarding to the claim which the learned friend has. Because I'll tell your lordship why is it relevant. Because his claim is for damages. Damages arising out of failure to give him a land so that he can set up. Now, Milord, in the proceedings between Tata and Shingur, where, Milord, this damage claim was also there, Milord, the question arose as to whether if the legislation on the basis of which, Milord, this acquisition was done has been held to be null and void, whether, Milord, the parties' loss fall there or they are entitled to damages. Because I was not instrumental. The Supreme Court which has said that no, your legislation is wrong. So, Milord, that would be relevant in my respectful submission for meeting one of the limbs for meeting the damages. Now, Milord, if I may show you, lordship, Milord, the application. Application GA. Milord, kindly take GA6. GA6 ta lordship ke dekho.
Yes.
Kindly, Milord, come to, Milord, page 12 straight away. Milord, even lordship makes a note, Milord. The suit was filed in 2021. Kobe 2020.
Page 12.
Well, page 12 will come later. Just 3 dates. 2021, the suit was filed. In August 2021 itself, we filed our written statement.
2021 suit filed.
Yes, Milord. But it was initially CS 33 of 2021. Your lordship will get it from the cost title. We filed our written statement in 2021 itself. Right?
In time.
23rd August, yes. Now, in 2023, Milord, my learned friend files an application which is GA4 of 2023. After 2 years.
For
Formula disclosing of documents.
Yes.
And the order is at page 12.
Yes.
Milord, kindly, Milord, come to, Milord, the submissions are recorded. Kindly, Milord, come to para 9. After hearing, Milord, at page 16. Milord, judgment Sudhir Kumar and all those were cited. After hearing the parties and considering the materials on record, I find that there has been a procedural change brought in respect of suits filed in commercial division of this court and the suits filed in the ordinary original civil jurisdiction of this court. In case of a suit filed in the ordinary original civil jurisdiction of this court, the procedure laid down in Order 7, Root 40, read with the provisions of Order 11 of the CPC is applicable along with provisions of Chapter 2 of the original side rules of this code. In case of suit filed in a commercial division, the amended provisions of Order 11 of the 2059 are required to be complied with, which have been made applicable exclusively to commercial suits. The provisions of Section 16 of the 2015 Act, that is the commercial, have clearly indicated the overriding effect of the Act over other procedural law in case of procedure laid down in the said Act, which includes the amendment brought to certain provisions of the Civil Procedure Code. In case of a suit in ordinary original civil jurisdiction, documents which were required to be produced with the plaintiff at the time of institution, on having not been so produced, could be disclosed with the leave of the court in view of the provisions of Order 7, Rule 14, Rule 3 of the Civil Procedure Code. However, in case of commercial suits, which include suits filed in the commercial division of this code, the amended provisions of Order 11 have brought out more stringent compliance for disclosing additional documents. Ordinarily, documents which are not disclosed with the plaintiff in case of commercial suits shall not be allowed to be disclosed except under the provisions of Order 11, Rule 1, Sub-Rule 4, and Rule 1, Sub-Rule 5 of the CPC as applicable to commercial suits. The legislature has, by introduction of the provisions of Order 11, Rule 1, Sub-Rule 4 and Rule 1, Sub-Rule 5 of the CPC, has made a distinction between such provision and the provision of Order 7, Rule 14, Sub-Rule 3 of the CPC. In view of the suits in ordinary original civil jurisdiction, a mere leave of the court is required to disclose additional documents. Documents in case of such suits can be disclosed at any stage, even during trial. The leave, however, is at the discretion of the court. However, in view of the provisions of Order 11, Rule 1, Sub-Rule 4 and Sub-Rule 1 of Sub-Rule 5 of the CPC, as applicable to commercial suits, the leave is qualified. The plaintiff petitioner, in case of Order 11, Rule 1, Sub-Rule 4, has to satisfy that there was urgent filing of the suit and the additional documents are to be disclosed within 30 days of filing of the suit upon obtaining leave of court. Here, below, it was an urgent filing. Order 11, Rule 1, Sub-Rule 5 of the CPC also stipulates that the plaintiff petitioner shall not be allowed to rely on documents which were in the plaintiff's possession, power, control or custody and not disclosed along with the plaintiff or within the extended such and such, and as such leave shall be granted only to the plaintiff establishing reasonable clause non-disclosure along with the plaintiff. The procedure to disclose additional documents in case of commercial is very stringent, but the same is not absolutely prohibited. On considering the case of the plaintiff petitioner in the light of the discussion as aforesaid, it is apparent that the plaintiff petitioner could not have disclosed the documents which were subsequent to the filing of the suit along with the plaintiff or even within 30 days from the institution thereof as required under Order 11, Rule 1(4) of the CPC, as they were beyond such period. The provisions of Order 11, Rule 1(5) therefore will be applicable in such a case. This court is satisfied that the plaintiff petitioner has established reasonable clause for non-disclosure of such documents along with the plaintiff, and as such those documents should not be allowed to be disclosed. The argument advanced by the defendants that without the amendment the post-suit documents cannot be relied upon is also not acceptable at this stage, as the court is not concerned with the amendment of the plaintiff. It is for the plaintiff to decide whether they will amend the plaintiff or not. The law as to evidence being laid regards the pleadings is well settled. The defendant respondent therefore will be free to object to the additional documents being allowed to be relied upon at the time of trial, or can argue that the evidence on the basis of these additional documents are beyond pleadings and should not be considered. No prejudice therefore will be caused to any of the defendants in the event these documents are allowed to be disclosed. So far as the documents which are dated prior to the institution of the suit are concerned, the plaintiff petitioner is required to come within 30 days from the date of institution of the suit to seek leave of this court to disclose such documents upon establishing that the suit was urgently filed, resulting in these documents having been overlooked for the purpose of disclosing with the plaintiff. The plaintiff petitioner has not done so. The exception carved out to the Order 11, Rule 1, Sub-Rule 5 of the CPC has not been satisfactorily meted in the instant case, as there is cogent ground establishing reasonable cause for non-disclosure along with the plaintiff has been stated. On a perusal of the documents which are prior to the date of institution of the suit, it is however found that these are third-party documents being mainly invoices raised on the plaintiff petitioner. This is the evidence, my lord, which is now coming in, which was not there in the previous suit. Even if the plaintiff petitioner is not permitted to disclose these documents, then also by laying down the foundation to lead secondary evidence and thereafter by issuing subpoena to the plaintiff petitioner, can have these documents produced in court and evidence laid on the basis thereof as envisaged under provisions of Order 16, Rule 6 and 7 of the CPC. So, my lord, what you can't do directly, the court has shown you the way. So, basically, my lord, what I can understand from this is that the court didn't want anybody to be shut out. So, very well.
That's
You
why
are
on the last occasion, another application I was hearing that I told the bar, why you are going by this sort of applications? Though in the district judiciary, there is a provision for witness summons for production of the document. In the original side, there is a subpoena. So if only subpoena, you have to satisfy the document is required for the proper adjudication.
So relevancy of a document will come at trial. So at this stage, to say that no, I will not allow you to rely on the document, my lord, if I have understood Order 11 correctly, my lord, is to give the impression to the courts that don't allow people to misuse Order 11 for the purpose of bringing in documents lately to delay the process. So that discretion, your lordship will, if your lordship sees Order 11, I need not place any further because ultimately he was allowed to disclose documents. If your lordship sees Order 11, it has two parts. The first part is, my lord, in respect of plaintiff, and from Rule 7, my lord.
7 to other 10, the defendant.
Now, one thing is common, my lord, in both the two exceptions.
Production of the document.
Yes, production. That which says, my lord, nothing in this rule shall apply to documents produced by the defendant and relevant only in answer to a case set up by the plaintiff subsequent to the filing of the plaintiff. So, my lord, if my learned friend is allowed to disclose documents subsequent to the filing of the plaintiff after 2 years by virtue of this, my lord, then under Order 11, Rule 7, P2, my lord, I think, my lord, my client should also be given an opportunity, my lord, to meet those documents, relevancy of which, my lord, will obviously be decided.
Yes.
My lord, from 7, my lord, the defendant's obligation starts.
Correct.
The only exception is see the 3 documents. For cross-examination, the plaintiff's witness is 1. In answer to any case set up by the plaintiff subsequent to the filing of the plaintiff.
Where from you reading?
My lord, Order 11. Order 11, Rule 1, Sub-Rule 7.
Referred and relied by on defendant in the written statement, document relating to any matter in question in the proceedings.
My lord, kindly come to Rule 7, Order 11, Rule 7. The defendant shall file a list of documents and photocopies of all documents in its power, possession, control or custody pertaining to the suit, along with written statement on its counterclaim, if any, including, my lord, this is not relevant. A is not relevant here, B is not relevant here. Kindly come to C.
Yes.
Nothing in this rule shall apply to documents produced by the defendant and relevant only in answer to B.
Yes,
in answer to any case set up by the plaintiff subsequent to the filing of the plaintiff. Now, my lord, 2 things. I had taken the point that so far as the subsequent documents are concerned, my lord, kindly, my lord, come to paragraph 12 once again.
Yes.
At page 18, last paragraph, the argument advanced by the defendant that without amendment, the post-suit documents cannot be relied upon is not acceptable at this stage, as the court is not concerned with the amendment of the plaintiff. So he has not made any application for amendment, but he has brought in the documents. I said that it is not supported by pleadings. The court said need not be. it can be brought in by way of subpoena. So, my lord, court found a way out for the plaintiff. Now, my lord, if this way the document comes in, then, my lord, a new case is set up on the basis of documents without amending the pleadings. The outcome, my lord, I have this liberty. But to meet this document,
Yes.
to meet this document, my lord, I believe the legislature has given me the protection under C2.
Yes.
That if a subsequent, suppose, my lord, in my written statement, I make out a case that no reply was given.
Yes.
And thereafter the plaintiff brings a record to negate that claim that no, this is the reply. Then I may get a chance to meet that because my written statement is already on record. Here, my lord, he doesn't want to amend.
So what document you want now?
My lord, I have relied upon the inspection.
Where is the document you disclose? Not in this application.
No, my lord, I have filed the affidavit of documents.
Which is the under challenge because in the written statement there is no document.
Yes.
So he can't file an affidavit of documents which is not disclosed in the written.
In this application, you are not disclosed.
In this application, he is attempting to disclose, subject to if the court allows that affidavit of documents will be admitted.
My lord, this affidavit
of documents can't be filed beyond the written statement.
This affidavit of documents was I was directed to file affidavit of documents. I have filed it. I offered for inspection. My learned friend is refusing to take inspection on the ground that this is not part of the written statement. And my lord, I have expressly, this is on record, my lord, I have filed it in the suit. Dekhun to eta court e thakbe.
Affidavit document.
Order টা কোথায় আছে এটা? এখানেই আছে তো? Kindly, my lord, দেখেন affidavit টা এরকম Gautam Chakraborty, 7th April 2025. Now, my lord, kindly see this affidavit was filed pursuant to the order at page 24.
Page 24 of this?
Of this application, Page 25, para 6.
Yes.
I give a letter at next page, my lord, page 26.
Yes.
I offer inspection of these documents. And my lord, in 27, he refuses.
Correct.
So this is the case, my lord. These are the documents which I want to rely upon, which is part of.
Where is the document?
Well, I was directed to file affidavit. My lord, documents have offered inspection.
How can you offer inspection without the
Could have
disclosure of
disclosed
document?
the document in the application. The court has to examine the document.
I can give it by supplement.
No, this can't be done.
You have not disclosed the document in the application.
No, my lord, I have not disclosed the document in my prayer in
the affidavit document with the part you have given the list.
Gives you a moment. My prayer in the application, my lord, is page 10.
Granted leave to disclose the document
Granted leave to disclose the document mentioned in the affidavit of documents filed on 7th April. This is the one.
Correct.
So, my lord, if your lordship, because I am out of time, I am seeking the leave, the same leave is there. If your lordship gives the leave, I'll file the documents. But documents which I want to intend to disclose are here.
No, that's why you have given the list of documents.
Yes. And I offered inspection also.
Offer inspection, they refused. Then you preferred this application.
Yes.
Preferred this application.
Yes, for giving leave to
disclose the document as they are taking the objection. It is not disclosed in the written statement. This is the now you file this application, but you have not disclosed what are the documents.
Milord, I have not annexed these documents, right? But I have referred to these documents.
Court has to examine the document.
I was under the impression at this stage, if your lordship wants to examine the documents, then I'll file a supplementary affidavit. I thought, Milord, these documents, because if your lordship sees the documents, if your lordship sees the list of documents, Milord, don't get excited. your lordship will find that all these documents are common documents. If my learned friend says that no, even if
they already disclosed this.
some of them are already, they're pleading that some of them are already part of their pleadings. Be that as it may, my lord, let's not go into that. If your lordship wants to examine these documents, I'll bring it tomorrow by way of an
The
affidavit.
document is to record.
Very
Just to look into.
আছে এখানে আছে Well, I have the, but there is a compendium. Well, it's just bulky. আছে Well, I need only one-page affidavit pursuant to the leave granted. I'll file it by tomorrow, Monday.
The defendant has filed the present application being GA Com 6 of 2025, praying for leave to disclose additional document. On the ground that
14 and
as per the
15
leave
are
granted by this court, the defendant has disclosed the document along with the list of has disclosed the list of document to the defendant to the plaintiff by a letter dated by a letter dated 22nd April 2025, but the plaintiff by a reply dated 25th April 2025 refused to inspect the document and to give inspection of the document on the ground that the defendant had not disclosed the said document along with the written statement. Accordingly, the present application is filed. The counsel for the plaintiff has argued the matter, defendant has argued the matter at length, but this court find that the document which the defendant intends to disclose in the present along with the written statement, the defendant has not disclosed the said document. Accordingly, the defendant is granted leave to file the supplementary affidavit disclosing the document which the defendant intends to disclose the same in the suit after serving the copy to the counsel for the plaintiff. Let the same be filed by
Monday.
By 16 September 2025, list the matter on 18 September.
কেন সম্ভব?
The common documents, plaintiff's documents, and dependent documents which are competent.
Yes, that is their document. So that's why Mr. Dutt has argued that there are some documents. Let the document examine which documents are common. So if the common document is there, the question
There's
is
three common documents from what I've seen in the affidavit.
okay.
But
Let's
we'll come.
3 common documents and 5 public documents, of which 2 are the Supreme Court judgments.
That need not be disclosed also.
So give me leave
Okay,
to rely upon it.
Supreme Court judgments
let
need
the
not be
documents come.
disclosed. Let the documents come in.
Lord, I'll file my affidavit. My junior is not there on 18th. Can it be on 22nd? 21st, nothing.
22nd, 21st is Sunday.
22nd.
23rd কর
এটা কি
give them
এটা কার একটা কি দেখুন না রয়ে গেছে obliged
great.
Well, would your lordship consider taking up the Passover matter? Lord, item 7, my lord, I was to, my lord, respond to Mr. Dotto. Lord, I can continue for, my lord, some time until your lordship calls the fixed
Continue.
matter.
How
Lord,
much time you will take? If you finish, I will allow you. If you not finish, I will not allow you. Then come after vacation.
after vacation.
Time to get a degree. He doesn't have a problem with
My lord,
that.
after I come back after vacation.
And he was very happy that Lordship has given him 15% interest in 3 suits. So it's my turn now, my lord. Today, Lordship, he was telling me, Lordship has delivered judgments. He got 15%.
So he will give the big party to all of you in the during puja.
And along with that, my lord, I now am entitled to a similar relief.
No, may I just, my lord, point out, my lord, there are, my lord, 3 possibilities. One is that he gets a decree. The other is that, my lord, I am put to some terms for contesting the suit.
So now what? See, Mr. Datta's intention is that you got the order before vacations, and he should also get the order.
He has no defense, my lord. He signed the settlement.
No, but I had a good case. I had a good case, my lord. Mr. Datta doesn't have a good case. My lord, equals are to be treated equally and unequals are to be, my lord, treated unequally. Article.
But sometimes it can be differentiate can be made.
But that won't, my lord, stand the test, my lord, of law.
And they should not take more than 10 minutes for Mr. Lakmani to come.
No, my lord, I will, my lord, kindly allow me to come back after vacation, my lord.
No.
My lord, I'll tell your lordship why. Because if I'm put to some terms, then my client will have to, my lord, make arrangements.
That is different.
That's always a unlikely. I'm hopeful I'll get an unconditional leave. But, my lord, there is a slight chance always.
Let him put in the money
See the confidence of Mr. Lakman.
There is a slight chance that I may be put to some terms. My lord, it will enable my client to just.
There is no chance of him being put to certain terms. He will suffer a decree in this matter. No. That's why he wants, my lord, after vacation.
Not at all.
My lord, we all understand these tricks. My lord, lordship kindly hears him and my lord reserves it. Or else, my lord, let him show his bona fide, ask his client to put in the money here.
My lord, I have to argue my matter. My lord, I'll show that, my lord, it's a book completely. My lord, a broker.
Okay, start.
My lord, order 13A. My lord, there are 3 possibilities here. One is that the suit is decreed as prayed for, which is, my lord, an exception. The other is that I am put to some terms as a precondition to contest the suit. And, my lord, the third is that I am given unconditional leave to contest the suit. Similar, my lord, to, my lord, order 37, those summary suits, same principles, uptown judgment, my lord, all of us know it. Now, my lord, if I have 0 chance of succeeding in the suit, there will be a decree. If I have, my lord, a good chance of or a reasonably good defense, my lord, I'll be given, my lord, leave to contest the suit. And if I have some chance, even if your lordship feels that I have a weak case, but even then, if there is some case, I will get leave, but your lordship will put me to conditions. Now, my lord, where in these 3 do I lie? That's, my lord, my argument. My lord, before
what is your defense first?
My lord, I'll take your lordship, my lord. No.
Not written statement.
No, they have to prove, my lord, they have.
Okay, no problem. What is your defense on?
I'm telling your lordship. My lord, for one day, despite being affirmed in time, I could not file my written statement. We went in an SLP, it got dismissed. My lord, that's our bad luck. Nonetheless, my lord, the only thing I have with me now is a right to, my lord, cross-examine this unworthy plaintiff.
Automatically.
So, my lord, may I just say this? Mr. Datta's client is on a DLF. He's not some real estate, my lord, tycoon. He's a broker. He classifies himself as a real estate advisor. But, my lord, these are essentially, my lord, people who crack deals. Now, my lord, in industry practice, a broker is entitled to a share of the rent. It's called a commission. He may classify it theoretically as a fee, but at the end of the day, my lord, a fee is not, my lord, a certain percentage of the outcome. A fee is what an advocate would charge, irrespective of whether he wins or loses a matter. But if I am saying that I am bringing you a party and you get into a contract with him for lease or whatever, and I'll get a certain percentage of what this person pays you, then that's a commission. Now, until that fructifies and attains finality, the broker is not entitled to any money. Because a broker's role, broker can't say, look, come, this is so-and-so gentleman. I have made the 2 of you meet. That's it. Now give me money. My job is done. He has to ensure that the deal goes through. Only when the deal goes through, my lord, is the broker entitled to money. And in their case, which they have...
Suppose he has bring the persons to you.
Yes.
You were complete. Negotiation was done.
Yes.
Subsequently, you directly went with the other person and entered with the agreement. What would happen?
Then he'll be entitled. That's not his case. That's not his case.
Okay.
Had this been his case, my lord, and my lord, I would have perhaps conceded.
No, I am not telling this case. I am.
Yes, yes, your lordship is correct. But if the broker brings him to me and we have a discussion, and at the end of the discussion he says, I will not pay you a rupee, then the broker will not be entitled to get any money. Broker is entitled to money if the person who's letting out his property is receiving even a rupee from this person whom the broker has introduced.
Okay, continue.
Malad, admittedly, not a penny has Malad come into my account. And they have flipped, they have changed their case in their reply. They plead that the agreement had attained finality, this transaction was final, etc. But in their reply, they made out a case that there was no obligation upon me to do anything apart from merely introducing A to B.
Yes.
This is now, Malad, a new case that they're running in their reply. Now, Malad, kindly consider their application. Malad, my contention is that I haven't received a penny from this so-called party who was introduced to me by this broker. Kindly now, my lord, consider the application. See, my lord, they're pleading what they pleaded in their petition and what they pleaded in their reply. My lord, kindly straight away come to paragraph 3.
Yes.
So, my lord, this is one issue. My lord, I have to show what is the issue which will be tried. Because if there's no need for trial, then your lordship can decree. So, this is one of the issue. Whether the interpretation of this contract, whether the interpretation of the invoice which they claim to have raised upon me, whether this is money payable only for introduction, or whether this was money payable as part of the rent received upon the deal being finalized. This is the issue. And this has to be tried. Now, my lord, kindly now consider. And my lord, it is absurd for a broker to say that I've just made the two of you meet, so you pay me money. Nobody does that, my lord. There might be instances of some solicitor, my lord, who introduces, my lord, the client to the counsel and takes a back seat in the matter. But a real estate broker can't do that, my lord.
So solicitor cannot claim the fee from the person who have been sent to you?
No, 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 no. No, no, my lord. Kindly, my lord, consider paragraph 3, my lord.
So not all the advocates you will not take.
Kindly take paragraph 3, my lord. The plaintiff is a company incorporated under the provisions of the Erstwhile Companies Act, but carrying on business inter alia so and so. The plaintiff is engaged in the business of real estate, consulting, marketing, and advisory services. Every broker's definition. He hasn't even constructed, my lord, something on a 4-kata plot, like those small builders do once in a while. Then, my lord, kindly come, my lord, to paragraph D at page 4.
Yes.
Negotiations ensued between the parties, which culminated into the respondent engaging the services of the petitioner and further agreeing to pay the petitioner a fee, kindly mark this, equivalent to 2 months' rent, as would be agreed upon between the respondent and its lessee. Which means that in the absence of rent, there is no fees. Because this fee is wrongly being called a fee, it is a commission. He is not a doctor who's performing a surgery that he'll be entitled to a fee irrespective of whether the patient survives or not. He is not a teacher who will be entitled to a fee irrespective of whether the student passes the exam or not. He is not an advocate who is entitled to a fee irrespective of whether the client wins the case or not. He is entitled to a commission if there is rent, if this deal fructifies. Next, in performance of its engagement, the petitioner took necessary steps to identify an appropriate lessee in respect of the said commercial building and finalized one Kalyan Jewellers India Limited, one of the most reputed jewelry retail outlets in India, as the proposed lessee of the respondent in respect of the said commercial building. So he was a proposed lessee. At this stage, my lord, the question of paying any money doesn't arise. Once he becomes a lessee and pays, I will part with the share. This is the question, my lord, which I want to, my lord, disprove, my lord, in the trial by way of my cross-examination.
What about the documents you agreed upon?
My lord, I will show you, I'll come to those documents also. This is the fundamental question. If this goes, everything else will fall like a pack of cards. I'll come to that, my lord. The respondent expressed its satisfaction as to the selection of the proposed lessee and proceeded to execute a letter of intent dated so and so, whereby and whereunder the said Kalyan Jewellers India Limited agreed to take on lease the said commercial building for a period of 15 years. My lord, for 15 years, I was, my lord, to earn 23 lakh rupees a month for 15 years from 2017. And for this benefit of 23 lakhs into 12 months into 15 years, which is a huge amount, I was parting with a paltry sum of 46 lakhs in my friend's favor, 2 months worth of rent. Next paragraph. Pursuant to such letter of intent, the respondent and the said Kalyan Jewellers entered into a lease agreement dated December 26, 2017, whereby and whereunder the demise of the commercial premises was completed by the respondent in favor of the said Kalyan Jewellers. The said lease agreement also specifically recorded in clause 7 that the monthly rent payable by the lessee in favor of the respondent was rupees 23 lakhs. This lease never took place. I will show the document which they rely upon. Then, my lord, kindly come to the next paragraph. Only 2 more paragraphs, and rest of it, my lord, I'll kindly just see 2 more paragraphs. Inasmuch as the petitioner had successfully performed, my lord, kindly see. This is, my lord, their own contention that unless there was successful performance, they were not entitled to money, which is why these, my lord, strong terms are being used. Inasmuch as the petitioner had successfully performed its contractual obligation by identifying, it doesn't stop here, my lord, and finalizing. Kindly mark the word finalizing, because in their reply, they have only limited their pleading to identifying and have disregarded finalization. By identifying and finalizing a suitable lessee for the respondent, and further by facilitating the execution of the lease agreement by and between the respondent and its lessee, the petitioner duly raised so and so, so and so, so and so. So a precondition for this bill is finalization, execution of lease, under which I get money, because I give them a certain percentage of my total receipts, that is 2 months worth of rentals. So even the fee, alleged fee, which is a commission, is defined as 2 months worth of rental being so and so. It's not that we've given you services, this is our fee, irrespective of whether you get 23 lakhs or whether you get 50 lakhs. Like, my lord, I have a fee structure. Whether I'm, my lord, doing a suit where the stakes are 20 lakhs or 2 crores or 20 crores, my fee doesn't change, my lord. Like a salon. Kindly now, my lord, come to the next paragraph. In furtherance of such FECON and revenue recognition, the petitioner proceeded to raise an invoice upon the respondent for a sum of rupees 46 lakhs together with GST, being in all a sum of rupees so and so. So this is, my lord, to show that it's 2 months worth of rent. Now, my lord, straight away, my lord, come to, my lord, the lease, the purported documents that they rely upon. Kindly now, my lord, consider page 40 of their application. This is, my lord, the letter of intent. And I haven't denied, my lord, the execution of this document.
Admitted.
This is an admitted document.
Yes.
This is not a contract. This is only a proposal.
Okay.
And my lord, how your lordship will ascertain that? Kindly see, my lord, at page 41, the third whereas recital. And whereas the second party intends to start their jewelry business. Kindly see that. And whereas the second party intends to start their jewelry business in the said premises, for which the second party has to do certain interior works in the said premises, which is accepted by the first party. This is a distinguished jewelry company. They were to come into my premises and make a full showroom out of it. For 15 years, I was to get rent. See the next line. Accordingly, the brief commercial terms of the proposal to take on lease the above mentioned commercial building as agreed. So this is a proposal. This is not the contract. Then, my lord, kindly turn over to the next page. At page 42.
So if you say this is the only contract, this has not been finalized. Correct.
Yes.
This is only your defense. You will not cross-examine further. Only your defense is that this is letter of intent is only a proposal. Further, it has not been finalized and you will not get any amount. This is your defense.
No, and the fact that I haven't received any amount.
Correct. It is not, you have not received any amount.
Yes.
So what is the tribal issue here?
Well, they have to prove that they are entitled to this money.
You are raising only the question of law that you have not completed, the agreement is not completed, that's why he is not entitled to get the...
No, my lord, may I, my lord...
And admittedly, not file the return statement.
My lord, no, my lord, the issue, my lord, which requires, my lord, trial is whether the plaintiff is entitled to a certain percentage of the money which I receive from the person whom he has given me, or whether, my lord, he is entitled to the money that he is claiming just by having allegedly introduced me to this person.
So that's why you show me, this is all in, show me the transaction, the negotiation was not completed. That's
Yes.
why no final agreement. Okay,
Yes.
where is that? Show me.
Yes, your lordship. So, my lord, I am so grateful.
That is your only defense.
Yes. Now, my lord,
your only defense is that he is the broker.
Yes.
The finalization was not done. That's why he's not entitled to 46 for GST.
Yes, my lord.
This is your
Yes.
simple case.
Yes, my
Show
lord.
me that.
I'm so grateful. Now, my lord, kindly just take, my lord. There was a subsequent, my lord, alleged document. My lord, kindly have a look at that document, which, my lord, at page 56. At page 56. This is, my lord, the alleged lease deed of 2017,
Correct.
which is undated and unregistered.
Correct.
They said there's a lease deed of 2017, December 2017. Here, my lord, this is 20 undated. Kindly see the first line. The deed of lease is executed at Kolkata this blank day of blank 2018. And, my lord, see the parties. Party 1 is, my lord, my client.
Yes.
One part. And the other part is this Kalyan Jewellers.
Correct.
And then kindly, my lord, come to 8. Whereas recital number 8 at the bottom of page 57.
Yes.
It is agreed between the parties that the agreement for sale between BP Suraj Business Combined Private Limited and Sajan Kumar Gupta, Shankar Gupta, Sunil Gupta and Anil Kumar Gupta shall be terminated within 60 days of the execution of this agreement. Any payment, kindly mark this, any payment of lease, rental, advance, security deposit under this agreement shall only be paid by the lessee to the lessor only on the termination of the agreement for sale. The handover date of the said premises shall be considered as 7 days from the date of such termination of the agreement for sale, and the rent-free period 3 months shall commence thereafter. Failure to get agreement for sale terminated within 60 days shall be a ground for termination of this lease agreement. Further, the lessor hereby undertakes to well and sufficiently implement. So, my lord, a precondition for this lease to even take effect,
that initial agreement
was that my agreement with, my lord, certain other persons was to be terminated.
Correct.
Now that termination battle is even now being adjudicated, my lord, before an arbitral tribunal, We are today, my lord, this was of allegedly of December 2017, dated, undated in 2018. We are in 2025 and that dispute, my lord, hasn't resolved. And which is why this lease was, let alone, my lord, being registered. It was not even dated.
Okay.
This lease agreement was not even given a date.
Okay.
It was given a go by.
Okay.
So I have not received, my lord, one paisa from these people whom Mr. Dotto's client introduced me to. And my lord, your pleadings, your lordship has seen those, my lord, pleadings, finalization of the contract, etc. Lease was entered into. Where is the lease? Under the Registration Act, it has to be registered. This is not even dated. Now, my lord, kindly please see, my lord, their reply. What is the case being made out, my lord, in their reply? Your lordship has passed orders, my lord, in my dispute with the other parties. I will show that. I will show the dispute that is pending.
No, 71. Kindly come to the 71.
Yes, my lord.
What is it? You confirm that.
My lord, kindly see, my lord, 72.
71. So first you come to the
70. My lord, this is the communication. My lord, kindly see, my lord. This is, my lord, 31st. Kindly see the date. I'm so grateful for this query.
Correct.
Kindly see the date on top. 31st December 2017.
Correct.
And in 2018, we entered into, my lord, the agreement which was signed, the lease, but which was never registered or dated. Hoping that, my lord, the dispute which was pending between me and, my lord, the other parties with whom I was in a contract for development, that would be resolved. There were tripartite meetings. My lord, I am not denying the fact that Mr. Dotto's client, my lord, was never involved. My lord, certainly, my lord, there were meetings, but nothing fructified because the dispute could not be resolved. I didn't receive a single penny.
So, okay, deposit condition and
My lord, why should I, my lord, deposit money when the precondition for money was my deal to fructify? A broker's duty, my lord, is to see that the deal goes through. He just can't come and say, and my lord, he himself has pleaded successful.
Hey, matter hai. Okay, come on Monday.
Very well. My lord, may I only pray for Tuesday instead, my lord?
Aye.
My lord, Monday I'm in some, my lord, difficult. Not in town, my lord.
Counsel for the defendant has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 16th.
Well, maybe request your lordship to mark it as a part heard matter.
Already burdened with the 500 matter of the appellate side. I don't know how it can be.
And now lordship has the appellate side matter also.
Yes, next.
Grateful.
And for the plaintiff, my witness was in the box. Correct.
There were some corrections, my lord, in the earlier
deposition.
On the other side.
Yes, she has informed, but she needs to communicate formally, which I'm.
We have sat and we have finalized, but I'll
Final
just,
and give to the office.
and I'll give it to them.
Amit Agarwal. Process resumed. Huh?
Can you say whether there was, can you say whether there was any requirement of carrying out of any pilot production test at the factory premises of the plaintiff? Can you say whether there was any requirement of carrying out any pilot production test at the factory premises of the plaintiff?
My lord, actually the pilot run test was supposed to take at the sailors.
Pilot production test was supposed to
take place at sailors factory. After that, once approved, the final installation and production was to be taken at my place.
Did you send the materials necessary for carrying out such pilot production test?
My lord, as the things was getting delayed and I was following up them regularly to provide the status of the machine, that how much it has been made. They were not replying that, so the materials for that was not sent for testing purpose, was not sent because it was at the back of my mind that they are only asking for material after receiving advance, and I was afraid that whether I will get the machinery or not.
Did you not require that the PE tube machines were to be specially customized as per specifications given by you?
My lord, none of the specification was given by me, as in the beginning I told them that I'm totally dependent on them. All the specifications and technicalities were to be provided by them only. Technicalities will be have to be provided by them only, on which I relied and approved time to time as they provided me and asked for.
So is it your case that the specifications and customizations were never made known to you by the defendants?
No, my lord, my case is to recover the money which I have paid to them as as the machine was not delivered as per contract, and there was breach at each and every steps from their end.
Were you not aware of the specifications and customizations according to which the machines were being manufactured or were required to be manufactured?
My lord, as I already said, that I was totally new in this business. I did not had any know-how. The same has been conveyed to them in our first know-how of anything. So in my first meeting, I informed the seller that I am totally dependent on them. They have to provide me the best thing and the latest technology, which is and the product which will be made should be acceptable by each and every industry all over the world.
The product which will be made, the product
Did the seller ever inform you? Answerটা গেছে। Did the seller ever inform you about the specifications and customizations according to which the machines were being manufactured?
No, my lord, nothing such was informed to me.
Have you never approved the specifications and customizations forwarded by the seller?
My lord, as I was totally dependent on them, whatever drawings they have sent to me and asked drawings and technicalities they have sent to me and asked me to approve those, I approve that, as Mr. Urmesh, the Indian agent of the company, was guiding me from time to time, and he is only approving everything on his consent. I was approving all the technicalities and drawings provided by them. On his consent, all the drawings and technicalities which they were providing from time to time. .
Are you still in touch with the defendant number 3?
No, my lord, I am not in touch of defendant number 3.
Please come to paragraph 33 of your affidavit of evidence. How did you come to know that the seller had already dealt with the machine for profit?
My lord, this information has been passed to me by Mr. Urmesh, the Indian agent of the Mr. Urmesh.
Information is para 33.
33.
The information in para 33.
पैराते information नहीं हमें बोले चाहिए.
अच्छा अच्छा.
Yes. By?
I have been informed by Mr. Urmesh that the machine has been sold to Pune party on their urgency, and which can be seen through one of his mail where he was offering me the leftover material of that party, which he offered me over the mail.
Which email are you referring to? Can you point out?
For that, can I have please judge's brief?
For that, I have to see the document.
For that, can I see the document, please?
Exhibit O. The exhibit developer. The witness. Against the witness.
He's mentioning something which you also.
30/11/2013. Reference টা বলে দেবে। Page number 2.
My lord, it's from the list of exhibit, page number 173, where a mail has been sent to me stating that below is the rate which I received from Pune. Kindly tell your decision as earliest, otherwise material will be shipped with the machine. And the mail below has the detail of the material offered to me with the prices.
This is forming part of exhibit 00.
Exhibit
00.
double O. Double O पे?
In the spiral volume which was disclosed, this is the document which the witness has identified.
Within bracket, witness
Refers to page number 173 of the documents disclosed along with his affidavit on evidence in chief, being the email dated 16 September 2013.
as part of exhibit 00. Huh? Double X. Fine. Double X. Page number? What is the page number, madam?
Your Lordship, this is page number 173.
173 of list of documents.
Yes.
Your list of documents.
So now this has been marked as exhibit XX collected.
Double X. That's
Double X collected.
double X.
Double X.
Part of exhibit XX.
Yes.
আগের ওটা কেটে দেবো।
Yes, next.
Mr. Agarwal, the email you have just referred to, kindly show where it is stated that the materials had been sold.
Which material?
Kindly show from the emails you have just referred to, being part of exhibit XX, that the machine had already been sold by the seller to a third party.
My lord, this
That you have
was
just now deposed.
informed by Mr. Umesh.
No, whether the specific question, whether the document which you referred to shows that the materials, what is it?
The equipment.
The equipment
Machines.
sold. We are sold. That is a specific question. It is reflecting or not?
My lord, no, it's not reflecting, but was informed through Mr. Umesh over phone.
Were you not informed specifically by the defendants number 1 and 2 that the machines were ready for testing and you should take steps for testing?
My lord, it was not informed by them. I was only chasing them whether it is ready or not.
Were photographs of the machine forwarded to you by the defendant number 1?
My lord, the photographs of the machines were forwarded to me by the defendant, but that also after number of follow-ups. and every time they delayed on asking for the photographs.
They delayed when asking for the asked for the photographs. করে নেবে নিশ্চয়ই। Kindly come to paragraph 34 of your affidavit of evidence. Kindly say when such request was made by Urmesh as alleged by you in the said paragraph.
My lord, Mr. Urmesh has requested me to terminate this contract, saving the reputation of his company, mother company, GCM. He requested me somewhere near about in November 2013. He said that if I do so, they will return my paid money and the reputation of defendant number 1, GCM, will not be hampered.
Where requests for I'll just reframe, were photographs of the machine not forwarded to you in the month of November 2013 itself?
In the month of November. In the month of November.
November 2013. If he's looking at documents, may that also be recorded that he checks documents?
No, my lord, in the month of November, nothing, no photographs were sent. It was sent earlier to that.
No photographs were sent. It was earlier.
Take the documents from
Page 197 of affidavit of evidence. Affidavit of evidence 197.
Yes, next.
So the defendants number 1 and 2 never directly requested you to terminate the contract. Am I correct?
Yes.
I am suggesting to you that the contract was terminated by the plaintiff due to fluctuations in the dollar rate and not at the request of the defendants number 1 and 2.
No, my lord. This contract was terminated on the request of defendant number 3 as he was instructed by defendant number 1 and 2, so that stating that you should mention the dollar fluctuation, because if I do so, then it will not hamper their reputation in the market and they will return me my money which I have paid to them.
Yes.
I'm suggesting to you that the contract was wrongfully terminated by you.
No, my lord. If ma'am can go through my documents which are submitted.
Only yes or no?
Uh,
Whether you are you have terminated the contract.
no, my lord, it's not by terminated, not by me.
Yes, next.
Are you aware that the defendants number 1 and 2 had invested substantial funds for manufacturing these machines?
Defendant number 1 and 2 invested substantial amount
For making these machines ready?
My lord, that only defendant number 1 and 2 can say, as from a layman point of view, if anybody has to make and supply the machine, they might have to invest, as they may have the stock of parts in their stock as well, or they might whatever the incur is there, they have to bear that. But there nothing as such was conveyed by them.
Nothing as such was conveyed by them.
Nothing as such conveyed by them. Yes.
Kindly take up Exhibit XX at page 197.
Shown page 197 being the part of Exhibit XX.
Would you now agree with me that the photographs were forwarded to you on November 20, 2013?
My lord, yes, I do agree. Earlier what I said was my mistake, as I did not remember at all.
Please tell this honorable court on which date Mr. Urmesh informed you that the contract should be terminated by you.
My lord, as I already told you, that it was conveyed over the phone. Exact particular date I cannot mention.
Was it before these photographs were sent or after the photographs were sent?
I'm sorry to say, my lord, it's totally a very old matter. So exactly this thing, I'm not able to confirm whether it's before the photograph was sent or after the photograph was sent.
I'm suggesting to you that you had terminated the contract because you had failed to fulfill and were not in a position to fulfill your obligations under the contract.
My lord, it's not true, because each and every time, one by one, modification and breaches were made from the defendant's part. They were delaying everything. And they only suggested me to cancel this contract.
I'm suggesting to you that the defendants number 1 and 2 had made the machines ready at substantial costs, and due to such illegal termination of the contract, the machines, my lord, I'll just refrain. I'm suggesting to you that the defendants number 1 and 2 had suffered substantial loss due to the illegal termination of the contract by the plaintiff.
That is already put your question. Already come.
My lord, loss and damage only I have a counter claim, so I'm just putting the counter claim.
Yes, what is the
The
question of the madam is that due to the illegal termination of the contract by you, the defendant number 1 and 2 has sustained substantial damages.
My lord, it was not cancelled by me as the machines were getting delayed in supply and it was not 100% ready as per them. And when I was following them again and again regarding the status of the machine, Mr. Umesh told me that they are failing to adhere the contract terms and the same has been leaked into the market, which is damaging their reputation. To save that, they advised me to cancel this contract, stating dollar fluctuation, and they will return me my paid amount, which should not go in loss on my account as per their statement over the phone.
When Mr. Urmesh had made such phone call to you, did he also join the defendants number 1 and 2 in such phone call?
My lord, he did not, because he told me that it was instructed by them to inform me.
Were you not informed that the machines were ready and should be taken, should be tested by you? Even after such intimation were given, even after such intimation was allegedly given by Urmesh.
Which intimation, ma'am?
Even after such intimation that the contract should be cancelled was given by Urmesh.
Till that time, he could not confirm whether the machine was ready.
Till that time, it was not confirmed whether the machine was ready.
I'm suggesting to you that the defendant is entitled to the counterclaim made by the defendant.
I could not understand.
The defendant has made a counterclaim. I am suggesting to you that the defendant is entitled to the counterclaim.
I disagree, my honor, because everything is paid by me only, and I haven't received a single thing from them.
Yes.
I'm suggesting to you that you have deposed incorrectly before this honorable court.
Could not get you what you want.
Okay, it is not.
I deny.
I disagree.
Are witness at all?
No, I don't have.
My witness will come from South Korea.
Close.
Yes, sir.
Okay, step down.
Thank you.
South Korea এখানে আসবে। Will come down. Time লাগবে? Time লাগবে। Visa permit সমস্ত
Plaintiff witness is present. Cross-examination completed. Witness discharge. Counsel for the plaintiff submitted. The plaintiff will not deduce any further evidence. Accordingly, evidence on behalf of the plaintiff is closed. Yes.
My lord, my witness is in South Korea. He'll be coming down to give evidence, and I'll need a little more time than usual, my lord.
When? Have you instruction? December he can come.
December he can come.
When? I am fixing a date.
My lord, any day. I'm okay with any day as soon as possible for them
matter
to bring
appear
the
on.
witness.
And my lord, পরপর যদি শেষ করে দিতে তারপরে চলে যেতে পারে।
চেষ্টা করব আমি না পড়ে affidavit বলতে পারবো না। করবো আমি চেষ্টা করব।
But if it can be consecutive dates, because then the gentleman who is coming down, he can maybe
But
not
for
every
that,
day.
I have to have the affidavit on evidence in chief in hand.
I will record.
Yes, I will consider that. I'll be coming fully ready to do the cross-examination.
15, 16 or मेरे ख्याल से इसका तो चला जाएगा। ठीक है, चलो देखो क्या 15, 16 and 22nd 17 भी है। ठीक है, 15, 16 and 17. 15, 16 कितना?
My lord, though there will be one difficulty. I need to have a look at the deposition before I go ahead with the cross-examination. Now, one day my learned friend is estimating that she'll be taking to complete the examination in chief.
Most of the documents are
Yes,
admitted
the documents will be there on record. I'll know exactly. But following day, even if I start, but if the cross-examinations are kept on 2 consecutive dates, maybe one day in between, and if the
Yes, I am
deposition
taking 3
could be,
days.
yes, and if the
15, 16 and
deposition,
17.
but 17th would again be on me because 16th, the deposition I won't get in hand before 17th. So that will be a difficulty for me.
15, 16.
Yes, one day in between will be good enough.
15. You will examination chief one day. It will
one
be
day,
completed.
my lord, because documents are mostly admitted. Some questions I'll have to put. There are some disputed documents. So one day will be enough, I hope.
Okay, 15, 16 and 18.
Great.
15, 16 at 3 p.m. 3 p.m. and 18 at 12:30 noon.
December
December. The defendant is directed to serve the advance copy of the affidavit of evidence to the learned counsel for the print.
Great.
Yes, next.
Lordship, item number 13, I'm for the defendant number 2. On the last occasion, the plaintiffs were supposed to file their reply to GA1. I have already filed my affidavit in opposition. They were to file their reply, Lordship.
You are appearing for?
I'm for defendant number 2, Lordship.
Who is for the plaintiff? Plaintiff raised for time to file. They have filed the reply.
No, Lordship, we have not been served with a copy of the reply.
Reply आया है क्या? Affidavit reply in GA1.
GA1, Lordship.
Reply they have filed. Not served to you.
Not served, Lordship.
9 September.
We have not received any copy.
Who has filed the GA1? Plaintiff.
GA1 is their application, Lordship.
Or interim
Judgment
order?
upon admission, Lordship.
Judgment upon it.
My lord, appearing on behalf of the petitioners, my lord, praying for a short passover, my lord. My senior was here, is now in some other courts, my lord.
Huh?
My lord, praying for a short passover, my lord. My lord, my senior was here, my lord.
Where is your senior?
My lord, until now he was here only, but now he's in.
There is your affidavit reply. You not serve the copy of the to the defendant of GA1. You have filed the affidavit reply in GA1.
Yes,
not served to the defendant.
My lord, I'm praying for a short passover, my lord. My senior will come and explain, my lord.
Not today.
Lordship, in that case, can it be kept any day next week?
Not today. Not today.
Not today.
On Monday.
Much
Grateful.
obliged. Much obliged.
Next.
My lords, I am appearing for respondent number 1. Mr. Ratnako Banerjee is appearing on behalf of us, but he is not available today as he is held up in an NCLT matter. Kindly fix any date after Puja vacation, my lord.
Whether Mr. Banerjee told you to make the submission that he is busy in the NCLT?
Yes, sir.
He has given the instruction that to make
Yes,
submission that he is busy in the NCLT.
Yes, my lord.
Yes.
Apologies for the inconvenience caused.
Next.
My lords, any date may be fixed, my lord.
Not today. Not today. Come on, Monday. Yes.
Much.
Plaintiff, my lord.
14.
Yes.
Not today. He is appearing for whom? Mr. Ratnanka? Not today. Next.
Lordship, for the defendant number 2, the
For the
applicant
defendant
in
number 1, my
the applicant in GA8. Lordship, on the previous occasion, there was an order. It was wrongly recorded, Lordship, in the order that the defendant number 3 has filed the GA. GA8.
On 8th of September, my lord, the matter was taken up. The GA7 and GA8, my lord.
Number 1 filed an application, GA7 praying for leave to file return statement to the contract claim. Filed by the defendant number.
Appearing for the plaintiff.
Defendant number 3 filed an application, GA8 praying for acceptance of the return statement.
That is the defendant number 2, it should be. We are for the defendant number 2, the GA8.
Huh?
In GA8, we are the applicant, the defendant number 2.
GA8, you are the defendant number 2.
Lordship.
You have filed the GA8.
Yes.
For what?
It is
Acceptance of return statement.
Lordship.
Acceptance of return.
Lordship. Lordship.
My lord, I was appearing for the plaintiff. My lord.
Yes.
My lord, GA7 and 8, Lordship had already issued directions on the last day, and GA1, so far as GA1 is concerned, that has been reserved by my lord Justice Arundam Mukherjee. My lord, but the judgment is yet awaited.
What is the GA1?
It's my lord plaintiff's injunction application.
And what about the return acceptance of the return statement and your counterclaim?
Well, that Lordship has already issued directions, exchange of affidavits. This order was passed last week only. I'll give you Lordship the.
It's on 8th of September. That order was passed.
Yes. Counsel for the plaintiff prays for time to file affidavit in opposition in connection with both applications. So, defendant number 1 has filed an application GA7 for praying for leave to file return statement to the contract claim. Who has filed the return statement?
Against that, my lord, the plaintiff has sought for filing
Because
the.
I raised an issue of maintainability of that application.
Correct.
But how can a co-defendant ask for my lord a leave to file written statement to the rejoinder
That
statement?
will be hard on merit, my lord.
So, have you filed the affidavits?
No, my lord. In fact, Lordship's order of 8th of September permitted us time till.
So why it has come today?
Lordship, it is because we have filed the application, so it was appearing
What
from
application
previous.
you have filed?
For acceptance of written statement, the GA8.
Item number 2. Defendant number 2.
Defendant number 2, Lordship.
But that has been also there.
That has been, Lordship.
And where the liberty is given to file affidavit in opposition in 2 weeks.
This matter is due to appear, my lord, again on 7th of November.
GA7 both have GA3 and GA8.
Lordship.
And GA7 and GA8 both the direction was given. Why it has come? Counsel for the defendant number 2 submits that in the order dated 8 September 2025, in page number 2, paragraph number 2, it should be recorded as defendant number 2 instead of defendant number 3.
Lordship. Grateful.
A copy
In the above, in the order dated 8 September 2025, page number 2, paragraph 2, it should be read as the defendant number 2 instead of defendant number 3. It is found that the matter is already fixed on 7th of November 2025. Please the matter on 7th November.
Grateful, Lordship.
Yes. So far as GA1 is concerned, I think
The copy has been served to the plaintiff.
Serve copy.
They are the co-defendants.
Serve the copy.
Lordship.
Next. Grateful, madam.
My lord, I appear for the respondent, your lordship. Respondent number 4.
And for the petitioner, my lord, your lordship will recall your lordship had allowed our review application.
What is the
There is
correction?
some
You tell me,
correction.
not to
Yes.
give any lecture. What is the correction?
Your lordship will take para 27.
Yes.
The previous paragraph read as, in the present suit, the father of the petitioner number 2 and the was a different number 2. The mother of the petitioner number 1 was different number 4.
Paragraph?
Paragraph 27 at page 10, your lordship.
Paragraph 2, the order is
Yes,
neither
it earlier read as, in the present suit, the father of the petitioner number 2 was the defendant number 2. It is correct, my lord. And the mother of the petitioner number 1 was the defendant number 4. Your lordship had corrected that, saying, in the present suit, the father of the petitioner number 2 was the defendant number 2. The father of the petitioner number 1 was the defendant number 4. Lord, the father of the petitioner number 1, petitioner number 1 is Anup Ojha. Father was never a party in the suit.
Because you persons are filing the application without describing that.
But
Every time you are coming with this Ojha is that son, this Ojha is that son, this
I
Ojha
completely
is
bow down, but perhaps your lordship.
Henceforth, I will reject your applications on that ground only. You are not giving the description.
I completely bow down, my lord.
And you are coming to review after the
my lord,
14,
about
20 days.
10 days after the passing of
Just
the
10
order.
days. You, how much time you take to read the judgment?
No, Mr. Ghosh had, mentioned the matter for correction, my lord.
After 10 days,
Yes, my lord.
then judgment is uploaded on the very same day. So court has allowed, yes, let us see when the other party will go to the appeal. Yes, defendant number 1, mother of the petition number 2 was the defendant number 2.
Yes, that is correct, my lord.
Just a minute. Father of the petition number 2 was the defendant number 2. Defendant number 2 was Pramod Rai Ojha.
Yes.
Correct?
Yes.
And the father of the petition number 1, who is the petition number 1?
Lord,
Anup Ojha.
Anup Ojha. Lord, father was Chimanlal Ojha, was never a party in the suit. But in fact, your lordship had allowed, saying that father was in the interim mode, hence Anup Ojha should be made.
Let me understand.
The defendant number 4 simply has to be changed to late Chimanlal Ojha. That is all. I think this is the short submission.
Yes.
That's why he's making confusion. So the father of the petitioner number 2 was the defendant number 2 is the correct.
Yes.
The father of the petition number 1 was the Chimanlal Ojha.
Was only Chimanlal, not defendant number 4.
That's all.
Yes.
And any other further correction?
Yes, my lord. Yes, my lord. Another thing, my lord. The defendant number 3, Girish Chandra Ojha, has expired.
Yes.
And my lord, your lordship has also recorded.
Just let it complete.
Yes.
Then?
Lord, then your lordship will take paragraph 33. Lord, when the order dated 3rd December 2018 was passed, at the time Girish Ojha, Maya Devi Ojha, Navin Chandra Ojha, Sriram Amritral Ojha were surviving members. Lord, Maya Devi Ojha admittedly had passed sometime in 2013. Right? In the second last line of that page, your lordship had written, after the order dated 3rd December, Maya Devi Ojha had expired. Lord, this after would be before.
In 2013.
Because she had passed in 2013. And my lord,
then?
And my lord, the second line of para 33, hence the name of Maya Devi Ojha will not be there.
My lord, Girish Chandra Ojha will also not be there.
Where?
Para 33, second line. The name of Maya Devi Ojha will not be there because she was not surviving at the time of passing of the 3rd December order.
Girish Chandra Maya Devi were not there.
Not there. They were not alive. Hence, that name should be omitted, and this after should be turned as before, my lord, subject to correction.
Next.
Lord, may I suggest over here, 33. Lord, we'll just not use the word survive. Because
Okay, next.
Lord, page 13, the first line. But it is also confirmed by the parties that Girish Chandra Ojha expired on 9 June 2016 at Brussels. But this GA 26 is still live and pending for deciding this issue.
In the
Yes, and my lord, we have the original.
Perhaps
in the earlier order, there was, I will not
correct,
correct this because
but
there is
the prayer of prayer of GA 26, which is again after restoration of the suit, is for the parties.
Sir, this is already on record. Already on record. That order I will recall.
I wanted to bring that to
you
your
want, I
lordship.
will recall that order.
I am not pressing
Then-
that. For your lordship's information, I must.
No, you persons have submitted and it is the order.
My lord, it was the submissions were made on our behalf, and my lord, we have the original death certificate
No,
being
it is in
operated
the
from
some
Brussels.
order. It was
Yes,
there.
yes.
Yes,
This
next.
application is pending. That
Next.
is the only thing.
Next.
That's all.
Yes, what is
Only one thing, Miller, has seen paragraph 33. Just the word surviving may be omitted.
And
surviving?
Surviving. Yes, for the only reason that as on that date, we didn't know whether Girish Chandra Ojha was still alive or
not.
So
in
that's
the
why
books-
Girish.
So in the books, Miller, they
No, that's why surviving. I am not. I am only deleting the Girish Chandra Ojha and Maya Devi Ojha.
No, my lord, Girish Chandra Ojha's death we came to know much later. Before your lordship passed this last order. Yes, my lord, only one thing, my lord.
I am not reviewing. Let it be continue challenge.
No, your lordship had recorded the death of Girish Chandra Ojha. Your lordship, kindly, my lord, the
Eraser.
defendant number 3's name has to be
This
deleted.
matter is mentioned for the correction, but I find that there is a contradictory between the parties, so the order is not required to any correction. Not required any correction. Next.
No, my lord, there is no contradiction as to the death of
Next,
Girish
next, call
Chandra
the
Ojha as
matter.
on date.
Call the matter.
Even my learned friend is also agreeing to that.
Call the matter.
I appear for the plaintiff respondent. The matter was fixed for filing
Oh.
written notes only.
Eraser देना उसको वो pencil वाला हटाओ उसको.
Okay.
Yes.
But this was fixed for filing written notes, madam. File or written notes.
Both the parties have filed written notes of argument. Both the parties have filed their written notes of argument. TV. Next.
Great.
Order item number 3.
None appears on behalf of either of the parties. No accommodation is sought for the interest. Let the matter appear in the warning list. Next.
4.
Same order.
5.
Same order.
2, 3.
I appear for the petitioner. It's a very old matter. I seek 2 weeks time to take instruction.
On time 92. You come next week. I will do. Otherwise, I dismiss the matter.
Next.
As per the prayer made by the counsel for the plaintiff, your plaintiff, let the matter appear on 19th under the same heading. And you come with what is the stage of the suit. Total details. Next.
Number 7.
Warning list.
Number 8.
Warning list.
Number 9.
Warning list.
10.
Warning list.
Number 11.
Warning list.
Number 12.
Warning list.
Number 13.
Warning list.
Number 14.
Warning list.
Number 15.
Warning list.
Number 16.
Warning list.
Number 17.
Warning list.
Number 18.
Warning list.
Number 19.
Warning list.
Number 20.
Warning list.
Number 21.
Warning list. Next, call the matter.
Quantum matter item number 22.
But I'm for the petitioner.
Item number 22.
Yes.
7 and 12.
Last order to the Well, our last order was of 1st August 2025. तुम्ही कहाँ है?
Respondent number 7 and respondent number 12.
But 8, 9, 10, 11, where my lord asked to take services of Ujani Chatterjee.
Yes, yes, yes.
1 to 6 prays for time to file affidavit.
Basically 1 to 13 all were directed to file their affidavits.
Yes.
Only my
You
lord,
are
I
appearing
believe.
for?
7 and 12.
You are appearing for? Either you argue with the petitioner or appear before
7
the
and
court.
12. He asked for who, or
You
what
give the preference to the petition when the court is asking the question.
respondent number 7 and 12.
Where is your affidavit?
I have filed it.
Have you served?
Yes, today, my lord, just today.
7. Where is it? 7 and 12.
7
Have
and
you
12.
served?
Just today, my lord, in court.
Okay. Yes, madam.
My lord, respondent numbers will contempt is 1 to 7, my lord. They were here, my lord, last week, and they have been able to come and execute a Vakalatnama. My lord, some time has been taken, my lord, because the appointment from the legal state services have taken a while. I am not ready with the affidavit yet, my lord. I will have to get in. They are not from here, my lord. So I will have to prepare that. If lordship will kindly grant me some accommodation, I will prepare it and have it filed, my lord.
How soon you will file?
My lord, I believe in it. If it can be posted after vacation, at your lordship's convenience, lordship. The difficulties, they are finding it difficult to come from here, from
They have committed
Muzaffarpur
the
in the
content,
village.
they have to come.
But they are actually the purchasers, my lord.
So why they have purchased? They have to inquire about whether there's an order of the
My
court or not.
interaction with them, my lord, has led me to understand that they were not aware of any of this.
They have to face the consequence.
Yes, my lord. I will prepare an affidavit on their behalf.
And 1 to 6 is not even represented the persons who have actually executed the deed.
1 to 6 appeared?
No, my lord.
Last occasion? Last occasion they appeared?
Yes, they appeared. Kindly see paragraph 5. Counsel for the alleged content number 1 to 6. Press for time to file affidavit.
Who has appeared?
Arindam Banerjee, if I am not wrong, my lord. By Shabir Ali Mirza and Topojit Das. But they are the ones who are doing the mischief. Really, Mrs. Chatterjee's client, my lord, are the purchasers. They are the ones in complete violation of the order, my lord.
8, 9, 10 you are appearing. 7 and 12 you are appearing.
Yes, my lord.
What about the 13? 13 is also there. Not only 12.
My lord, 13 was, my lord, the person, the registrar, your lordship, remember, sub-registrar who had appeared before your lordship.
Okay.
My lord, he has also not filed any, my lord, affidavit.
Record and the counsel for the alleged contender number 1, 7 and 12 has filed affidavit. After serving the copy to the land counsel for the petitioner, let the same be kept with the record. Counsel for the alleged contender number 8, 9, 10 and 11 press for extension of time to file affidavit. Full stop. None appears on behalf of the alleged contender number 1 to 6 and no accommodation is sought for. Full stop. The defendant, the alleged contender number 13
is, my lord,
also not appeared,
yes,
and has also not filed affidavit as per the direction passed by this court. In view of the above, let warrant be issued against the alleged contender number 1 to 6 and 13.
And I am appearing on behalf of 13. My lord.
The court will go to your house.
No, my lord.
Where is your affidavit?
My lord, it's ready, my lord.
You?
Yes, my lord.
Let's contender number 8, 9, 10 and 11.
Kindly grants me a
extension of time to file affidavit police. None of us on behalf of the 1 to 6, 13 KT then. No affidavit is filed. Police. Yes.
I was told that I just wait for 1 minute.
As none appears on behalf of the alleged content number 1 to 6 and the content and also not filed the affidavit of compliance, let warrant be issued against the alleged content number 1 to 6. The plaintiff is directed to take appropriate steps for filing requisites for issuance of warrant against the alleged content number 1 to 6. Police are returnable. Full stop. The alleged content number 8, 9, 10 and 11 are directed to file affidavit in opposition by 31st of October 2025 after serving the copy to the land counsel for the plaintiff. The defendant, the alleged content number 5 filed affidavit उसको रोक के रकम नहीं होगा तो हटा देंगे. Filed affidavit in opposition. Affidavit after serving the copy to the petitioner. You will file reply.
Reply to both sets of affidavit.
Given
by
liberty
7,
to file
12 and
reply.
13.
to the affidavit filed by the 7, 12 and 13 within 3 weeks. Let the matter appear on 31st of October 2020.
Only one intelligence may be pay for. My lord, let me then file the affidavit with the department because my lord, I will not be able to, and in the course of the day, my lord, I will serve the copy. It is my fault, my lord. I was told the file was here.
My lord, I don't stand in the way.
Okay, file in the department.
Learned advocate says he has the affidavit. I will believe that.
Okay.
Grateful to you.
Article 23.
I appear for the respondent number 2 in this matter, my lord.
Yes.
This is a contempt petition.
Hmm.
I don't know if the petitioners are willing to move.
You are for the?
I am for the respondent number 2, my lord.
Respondent number 2.
Yes, my lord.
Your Lordship, I am for the petitioner.
Hmm.
We have not been able to contact the Mr. Doot. He is not keeping well.
Who?
Our client, Your Lordship, Pavan Kumar Doot.
Hmm.
So I pray for an adjournment, Your Lordship.
Proceedings are complete in the matter. Your lordships have recorded it by way of my lord's last order.
As per the prayer made by the counsel for the petitioner, case is adjourned. Let the matter appear on 31st of October 2020. Next. Item 24.
Item number 24, I appear for the petitioner in this matter.
Yes.
My lords had passed your lordship's last order dated 18th July 25, directing the superintendent of police Jamui to file a report before your lordship. Your lordship will recall this is that matter wherein the respondent contender number 10, a warrant of arrest was issued by your lordships, which is yet not been executed.
How many contemners are there?
There are altogether 10 contemners, but the others have entered appearance before your lordship, save and except respondent contender number 10.
Azaz Ahmed. कोई नया रिपोर्ट आया क्या? ये रिपोर्ट कब का पहले का है?
Initially, they could not identify the individual because the father's name was not there, which subsequently we provided.
यही है. अरे तो by an order dated 18 July 2025, this court directed the Superintendent Police, Jamui, Bihar, to submit report within 2 weeks from date as to why warranty has not been arrested and as to why the report has not been filed. The order dated 18th July 2025 was duly communicated to the Superintendent of Police by speed post, which was delivered to the Superintendent of Police on 28th of July 2025. The Deputy Sheriff of Calcutta has filed a report wherein it reveals that in spite of receipt of the order dated 18 July 2025, the Superintendent of Police Jammu Bihar has not submitted any report. In view of the above,
I am for few respondents.
The Superintendent of Police Jammu Bihar
I have
is
to file
directed
Vakalatnama.
to appear before this court in person through virtual mode on 19th of September 2025 and to file report and to show cause as to why appropriate action shall not be taken against the Superintendent of Police Jammu Bihar for not compliance of the order passed by this court. Let the matter appear on 19th of September 2025 at 2 p.m. for appearance of the Superintendent of Police in person through virtual mode.
My lord, I understand that respondent number 9 is also not being represented before your lordship in the contempt proceedings. Initially, there was one gentleman who was representing the respondent number 9 who perhaps has withdrawn himself.
Yes.
I am not.
You are appearing for whom?
CC 57. I am appearing on behalf of 1, 2, 4, 5, 6, and 7.
Yes.
And the next matter, my lord, I am not.
I am appearing. This matter you are appearing for whom? 57. You are appearing for whom?
My lord, 1, 2, 4, 5, 6, and 7.
Correct. And 77?
77, my lord, for the same person, but as respondent number.
Yes, you have filed the affidavit.
No, my lord. What happened, my lord? It's a change brief, my lord. Earlier advocate did not file Vakalatnama. We are under the impression that we will get the NOC Vakalatnama in respect of the contempt proceedings. The earlier advocate did not file the Vakalatnama. Now, my lord, the two of the contempt, they are seriously ill.
Court has asked only one question, whether you file the affidavit or not. I am not want
my
to
lord, I have
anything.
my lord.
You are appearing. You are the responsibility. You are tell that you.
My lord, kindly bear me. Kindly bear me for a moment. My lord, the client did not. We filed a certified copy on the first occasion, first day of our appearance. We asked for the copy, spare copy on our cost. They refused to give.
Where is the communication made to the petitioner? Where is the communication?
Yes,
show me the communication. You made the communication to the petitioner for service of copy.
Yes. So you have. Because I've been instructed that we've already served the contempt petitions on the respondent.
The plaintiff as well as the department is also.
Yes, my lord, this is the communication.
Communicate this order to the Superintendent of Police for compliance.
So, Mr.
16th April.
Yes, my lord. Thereafter, I filed for. Yes, my lord. Thereafter,
but on the matter was taken on.
My lord, in respect of CC, in respect of that CS, my lord. But in respect of CC, my lord, contempt proceedings, the earlier advocate did not file Vakalatnama. We are under the impression that
You understand the English, no?
Yes, my lord.
The court has asked the question. Only one question has asked whether you file the affidavit or not.
My lord, the client
stated that you have communicated. They are not. So this is not with regard to the CC. It's the April. Where is the communication made to the petition with regard to the CC?
My lord, we are yet to receive the Vakalatnama to be filed, my lord.
So you are not appearing, na? Your Vakalatnama is not there.
No, my lord.
Okay, so you sit down. You are appearing for 1, 2, 4. What about the other contemners?
Other contemners, my lord, respondent number 9 was earlier being represented by one Mr. Oriji Chorkar. This your lordship will find by way of my lord's order dated 18th December.
Whether they are appearing today and they
no,
file
none
affidavit?
of them. None of them are appearing. My lord.
The other contemners, the contemners number 1, 2, 4 to 7, 9, and 10 have appeared before this court on earlier occasion, But today when the matter is called, none appears on behalf of the alleged contemners. Full stop. One none advocate, what is your good name?
Devopriya Samanto.
So and so appeared and submits that he is appearing for the different alleged contender 1 to 4 and 7, 1 to 4 to 7, but he has no Vakalatnama on behalf of the said alleged contemners. Accordingly, it is not possible for this court to hear the learned advocate on behalf of the alleged contemners. In view of the above, let the warrant be issued against all the contemners. Full stop. The petition is directed to take appropriate steps for filing requisites in the department for issuance of warrant against the contemners.
Raj, I am grateful.
Let the matter appear on
19th
of September 2025 for appearance of the Superior Police in person through virtual mode and virtual mode. Full stop.
I am
Next.
grateful, madam.
उसमें बोल रहे
আমি দৌড়ে দৌড়ে এসব মামলা করবো
contradict incorrect same next
26 I am for the
19th
contender.
It will come on 19th.
On 19th?
It is fixed on 19th.
Very good.
As per the last order.
I'm so relieved. Or perhaps it was mentioned and it was decided that it will come on 19th.
Yes, next.
Item 27. My lord, I appear for the petition.
Yes.
My lord, I am for the defendant number 1. I am praying for an adjournment today. I am being led by Mr. Altama Shalim. He is not in court today.
Have you filed the affidavit?
Pleadings are complete.
They have filed their affidavit. I am, my lord, a little out of time so far as reply is concerned. My lord, I am filing my replies. My lord, there are two contempt petitions, item 27 and 29. I am filing the reply in both the contempt petitions.
Okay, and okay. Item 27 record. Counsel for the plaintiff has filed affidavit in reply to the affidavit in opposition of the affidavit in opposition or affidavit of compliance. What?
My lord, this is affidavit in, my lord. আমাদেরটা তো reply. This is reply.
Opposition. Let the same be kept with the record. Counsel for the alleged contender prays for time. According case is adjourned. Let the matter appear on 31st of October. 29.
29 is
29
another contempt, same order, my lord.
And 41.
There is another application between the same parties, 41. That's for modification of your lordship's order. Since they are not here, my lord, they will again take time. So lordship keeps it also, my lord.
Which one?
Item 41.
Let the call will.
Okay, very.
Yes, next.
28.
27, 29, huh? You 28. Yes. Affidavit in opposition 2 weeks. Reply 1 week. Opposition filed. Filed. Which was the petitioner?
After Millard lost interest, Millard after having Millard suffered a defeat in appeal court. Must have lost interest.
So then last occasion also not appeared.
They'll not stand. Last
Today also not appeared. Who was appearing?
Mr.
Bhattacharya. Counsel for the alleged contemptor is present. None appears on behalf of the petitioner. This court find that the matter was fixed on 18 July 2025. On the said date also, none appears on behalf of the alleged for the petitioner. Today also, when the matter is called, none appears on behalf of the petitioner. No accommodation is sought for. This court find that the petitioner is not interested to proceed with the contempt proceeding. Accordingly, contempt proceeding is dismissed.
Grateful.
For default. Yes, next. 29 over. 30.
Item 30 might appear for the petition in the contempt proceeding.
But I am for the contempt, my lord. On 1st August, my lord, I have indicated that the order has already been complied with.
But there was direction to file before the registrar original side the documents with regard to the property at Salt Lake. So this has been done. The only difficulty I face is the sanction plan which is given after an inspection, was in my lord's leave. The sanction plan is a revised sanction plan. The original sanction plan is not given. That is the only thing. Others are there.
So in that
It is stamped as revised.
whatever it may
It
be.
is stamped as revised. The original is not given. That is the only
Original is not given. On original plan was.
original. Yes, original. No,
What
the
was-
original
what
is
was-
given.
What was the order?
Oh, mother.
What was the order?
Yes, order. Last order is parent order type. On my brief. Oh. My lord's order is at page 57 of the brief. Yes. Page 57 is the order, my lord.
Yes.
Is my lord's pleasure to come at page 60 is the operative portion.
Original death certificate, original copy of all sanction plan.
Yeah.
All sanction plan.
Now, paragraph 6 is at page 31. Paragraph 6 mentioned in my lord's order, internal page 4 is at page 31.
31.
Yes. Paragraph 6.
Yes.
Yes. These are the list which.
Yes, original sanction.
Yes. So, copy of all original sanction building plan. The original has come. What has come? The revised building plan. The mother building plan has not been given. If a direction is given to inquire to the advocate, where is the first.
The mother building plan would probably not be there because the building plan of the revised sanction plan that is in operation right now. That is the sanction plan only.
Where is the mother building plan? You might.
That I have to take instruction whether it is in hand or not because the mother sanction plan is not in existence now. Revised sanction plan is the only thing in existence.
If you an affidavit, there is no mother sanction plans in your
But I have
hand.
to take instructions. I have to take instructions in response to that.
The counsel for the petition submit that though the alleged contemners are alleged contemner or contemners?
Contemner, one, singular.
No.
The mother was the contemner. As per the order, the mother has to produce the documents.
Contemners have submitted the original documents in terms of the order passed by this court dated 16 January 2025 before the registrar original side of this court. But learned counsel for the petitioner pointed out that the item number B, the document mentioned in serial number B, that is the original copies of all sanction plan of the building at BJ-86, Salt Lake City, Kolkata 91. With respect to the said document, the alleged contemners have only filed the original copy of the revised building plan, but have not filed the mother sanction order.
Plan.
Sanction plan. Full stop. Counsel for the alleged contemner submit that he will take instruction from the contemners whether the mother building plan is available with the alleged contemners or not. In view of the submission made by the
we can record
the alleged contemner.
In the event is not there, the undertaking.
The case is adjourned till 26th of September 2025 or
Or kindly not keep it on 26th, my lord. I am not there on the 26th. My lord, kindly keep it on 19th then.
Okay, 19th full stop. It is made clear that if the alleged contemners is having the original or copy of the mother sanction plan, the same will be placed before this court on the next date fixed. If the contemner contends that the mother building plan, other sanction plan is not available, the alleged contemner shall file an affidavit file the same on affidavit that the mother building plan, mother sanction plan is not available with the alleged contemner on the date fixed.
Deeply obliged, my lord. Deeply obliged.
19th of September 2020. Next.
Lordship, item number 31, my application for contempt appearing for the first time.
Yes.
Lordship's order is page 41.
Page?
41, my lords.
Yes.
6th March 2025. The direction Lordship will get in page 43. The Lordship just kindly comes, or Lordship just kindly comes to page 44.
Concerning the above submission, the plaintiff has made a fantasy case balance of convenience. It further thus the defendants, their men, agent, representative, servants restrained from publishing or posting any of the statement concerning the punishment of the plaintiff in the pending investigation, and also direct
And
the
also
defendant
directs the defendants
articles.
for
Yes.
to take out the application.
Hmm.
Lordship post this order. The order was served. The affidavit of service I have filed in the suit, Lordship. So I have kept a copy of it, which is appearing page 45, served upon them. The defendant number 1, there is a respondent number 1 has taken it down. The respondent number 2 and 3, as on date, still hasn't. I have annexed a copy of this article in page 62. The Lordship just kindly takes up. This is a copy of the article by the defendant 2. Lordship sees top left. It is of 7th July 2025. Top left, my lords. And similarly, of defendant number 3, Lordship will get in page 67, top left, Lordship 7th of July. So the articles are still in their web portals, my lords. And I should be candid, Lordship, defendant number 2 has entered appearance and has also filed a vacating application, which is pending consideration. But the article still remains as on date, my lords. So I was praying that notice can be issued to both
Issue notice upon
Lordship.
The petitioner has filed the present contempt application on the allegation of violation of the order passed by this court. Data, where is the order dated?
6th of March 2025.
Dated 6th of March 2025. 6th of March 2025. Counsel for the petitioner submit that in spite of the order passed by this court, the alleged contemners have not complied with the order passed by this court according. Considering the submission made by the counsel to the petitioner, let the notice be issued upon the alleged contemner returnable by 31st of October 2020.
Grateful, my lords. Grateful.
This is the matter on 31st. Next.
Grateful.
My application for contempt was appearing for the first time.
First time?
Yes.
Where is the order?
Well, the order.
I appear for the defendants, my lord, in the originating summons, my lord.
So you are appearing?
Few things, my lord, ought to be indicated, my lord.
You will accept the notice.
Ex parte order was being obtained behind the back, my lord. A vacating was pending.
Naturally, ex parte without hearing.
There is a demurrer application taken out by us that has been heard out by the coordinate bench of this court, my lord. Both parties have concluded with the argument, my lord. At the face of it, my lord, I had tried to demonstrate, my lord, the suit itself is not maintainable, my lord.
Correct.
None
But
of
the
these
interim
are
notice
grounds
is
for-
still there.
None of these
Interim
are
is
grounds
there,
for
my lord.
defense of contempt.
Interim
So
notice
we do
is
not
still-
know what alleged grounds my
That's
learned
right.
friend is
So
trying
let-
to
so
take
let
out,
me-
my lord.
let
May a
me
copy
place
be
it-
served upon us, my lord. We consider and come back, my lord.
We will
consider and come back, my lord.
We will serve that first. Let me satisfy this court, because if the court is not satisfied, there is no question of contempt not being served. Kindly come to page 84, my lord. 84.
Yes.
My lord, this is the starting of the commencement of the order. Kindly straight away comes to my lord, page 88.
Yes.
Accordingly, the defendants are restrained from operating the bank account number such and such, last digits are 9656, maintained in the name of the trust in the State Bank of India, Entally branch, till 3rd October 2024. Plaintiffs are directed to serve the copy of the application along with the plaintiff documents to the defendants and to file an affidavit of service. So, my lord, on and from, this is the order, is dated, my lord, 29th August.
Yes.
My lord, they are restrained from operating the account of the trust. Kindly come to page 90.
90.
90. This statement is provided to us on 3rd October 2024 by the bank after repeatedly writing to the bank as to what is happening in the bank account. My lord, kindly see, transfers, debits have been, my lord, carried on right from, my lord, 1st September, 3rd September, my lord, last two entries. Before that, my lord, 15,000. Also, my lord, September, 15,000. Then, my lord, turns over the page, my lord.
Yes.
3rd September, 5th September, 4th November, 4th September. 1 lakh on 4th September, my lord. First, second, third entry from the bottom. Then again 1 lakh. 4th September.
Yes.
Then, my lord, 5th September, 20,000.
My lord, I don't think anything else needs to be shown. And my lord, kindly come to my lord page 112. I have my lord by letter, the lawyer's letter, my lord, asked upon them my lord, as to how they can, my lord, all the contemners as to how they can do this, as because there is an order of injunction.
Yes.
And basically, we have sought for bank statements. My lord, today, my lord, I know naturally, my lord, the contemners have to be served. But all I need, my lord, an additional prayer, my lord, today. And since my learned friend is appearing, my lord, let them disclose the bank accounts as to what has happened, the statements, right from 29th August till, my lord, today, so that we know, my lord, how the order of injunction, if at all, has been violated. That's all. And let them answer to the rule, because
Yes.
obviously they will say they have not violated.
Proceedings, in the contempt proceedings, my lord, this is really unheard of, my lord, a direction for seeking bank statements, my lord.
Why?
But however, my lord, I'll disclose everything in by way of a filing of affidavit, my lord. You do not know what my learned friend has indicated in his application.
The petitioner has filed the present contempt application on the allegation that contemner or contemner?
Contemners.
Contemners have violated the order passed by this court dated
All defendants, my
29th
lord.
of August 2024. He submits that by an order dated 29th of August 2024, this court restrained the defendants from operating the bank account number 000 6 time 317-160-19-656 maintained in the name of the trust with the State Bank of India, Entity branch. Counsel for the petitioner submits that in spite of the order passed by this court, the defendants have operated the bank account and withdrawn or transferred the amount from the said account. As an advocate appearing for the appearing for the alleged contemners, accordingly, the petitioner is directed to serve the copy of the contempt application along with the document to learned advocate on record of the defendant by tomorrow.
By tomorrow,
By
Monday.
By 16th of September 2020.
My lord, so deep.
No, 16th of
15th.
19th of September 2020. क्या है? 16th करो.
Yes.
16th of September 2025. Police stop. The alleged contemners are directed to file their affidavit
indicating that
affidavit
along with
specifically dealing with the documents relied by the defendant and relied by the petitioner appearing in page number
90 and 91.
90 and 91 of
And also if they produce the entire bank statement, because the bank is not giving us the entire statement.
the let the matter appear on. How soon you file? Let the affidavit be filed.
My lord, difficulty, my lord, the defendants are not residents of India.
They have
But,
given power of attorney.
sometime I was praying. Some
Let them
reasonable
not-
time, immediately after reopening, lordship keeps it, my lord.
Let the affidavit be filed 2 weeks from date. Reply, if any, there to be filed within a week thereafter. List the matter on 7th of November 2020.
2 weeks from reopening, my lord, your lordship?
No, 2 weeks from here.
Then, my lord, 1 week after reopening, because 2 weeks.
I was praying, my lord, only one week after the vacation, by 1 week after
1
vacation.
week after the vacation.
We'll
But
file
even
it.
after 1 week after vacation, reply if any there to be within a week thereafter. List the matter on 21st.
But a bank statement in the meantime. If they are withdrawing money,
deal them.
but only
Deal
your lordship
the
has
allegations,
given
my lord.
direction 90 and 91. But
Let them
till
take out
date,
appropriate
till
application,
date,
my
the-
lord.
till date,
Well,
the
the
bank
appropriate
statement-
application has to be taken
let
out to that
them
extent,
come.
not in the
In the
contempt
entire,
proceeding.
entire
Not
1
in the
month.
contempt proceedings can allege all these things.
An order is there.
If they are still withdrawing, I do
Well,
not know.
that-
That's
let
why
them
I'm saying.
take out,
They file affidavit
Then
if you want.
that will be
That's the
clear, my lord.
Then that one line that up to date bank statement should be filed with their affidavit.
Cannot be in the
Let them
contempt
file,
proceedings.
There are
Cannot be.
judgments below which say that
Very well, let them take out appropriate applications. Extremely obliged, my lord.
My lord, in this matter, I'm appealing for respondent number 1. My lord, on the earlier occasion.
My lord, I am here for the petitioner, my lord. The plaintiff petitioner.
Yes, my lord. My lord,
For 30.
My lord, if your lordship recollects, my lord, this is a matter where, my lord, we say, my lord, there was a settlement agreement on the basis of which, my lord, 5 loans
Yes, as
to
per your case
settle.
that you have made the
Yes, yes.
overpayment, but the bank.
Correct, my lord. Absolutely, deeply obliged. My lord, they were required to commence submissions.
Yes, yes,
They
yes.
always say that they're in great urgency and suffering great prejudice because of the interim order. So, my lord, kindly allow them to continue.
Yes.
Yes. My lord, to that effect, my lord, initially, my lord, the matter was moved before your lordship. And the initial plea that was taken by my learned friend before your lordship was, if your lordship kindly peruse the order passed by your lordship on the earlier occasion, my lord. What is the exact cause of action of the instant suit against of which, my lord, they have taken out one ex parte application before your lordship. My lord, the observations of your lordship, my lord. Your lordship, kindly take up my affidavit in opposition, my lord. I have annexed, my lord, your lordship's order. My lord, relevant portion, my lord. Page 95, my lord.
Yes.
In the present case, the defendant number 1 has issued notice to plaintiff under section 13(2) of Surface Act 2002 on 5th March 2024, and plaintiff has given the reply to the same. The plaintiff have prayed for an ad interim injunction restraining the defendant number 1 from making any demand acting contrary to the agreement dated 30th January 2020. So, my lord, what my learned friend states that memorandum of understanding. So, my lord, their basic prayer was that what claim I have made in accordance with, my lord, section 13(2) notice that was sent by my client on 5th March 2024 not to act in contrary to the letter of understanding. So that is, my lord, their initial point. And that is why, my lord, they said and they approached before your lordship asking for injunction. And that is why, my lord, it is observed by your lordships. The notice against the plaintiff is seeking injunction issued by the defendant number 1 is under section 13(2) of the Surface Act 2002, and thus it is settled law that under section 34 of Surface Act, no injunction can be granted by this court. So that is, my lord, the initial prayer. And, my lord, the same prayer was, my lord, reiterated before, my lord, appeal court. If your lordship sees, my lord, next page, page 96.
Yes.
Before, my lord, Justice I.P. Mukherjee, Honorable Justice I.P. Mukherjee, and, my lord, the interim order in terms of prayer A. So, my lord, I will not trouble your lordship. Lordship straight away, my lord, kindly come to page 97. Yes. Mr. Satoru Banerjee, my lord, my senior in this matter, appeared. Learned counsel appearing for the respondent state that his client are in possession of the subject property. He submits that demand notices have been issued on the appellant prior to impugned judgment and order. That in view of the manner, we request the learned single judge to hear out the application on 21st June 2024 or they soon thereafter as may be convenient to the bench. Then, my lord, the subsequent portion, till the application is taken up by the court, the respondent shall not proceed further with any demand against the plaintiff. So, my lord, basic, their line of argument was, my lord, against my notice of demand. And such demand and such prayer with the change of days, with the flux of times, my lord, converted into, my lord, subsequent submissions. And it is, my lord, finally come to a submission stating that on January 2020, one letter of understanding was executed, against of which 4 borrowers are there, and subsequent 10 companies and person are guarantor. So the borrowers, out of 4 borrowers, 2 borrowers are in liquidations. So you cannot make their claim, and what payment and arrangement has been made in accordance with the letter of understanding, well, that is fulfilled, and even rather extra payment has been made.
That is a simple case, yes.
But my lord, the payment of the demand portions, which was my lord their inertia, subsequently my lord that was subsided with an argument stating that since I have made payment, so 2 persons, juristic persons are in liquidation, you cannot make claim. For that reason, your lordship be pleased to see my lord what are the prayers made by my learned friend in the injunction application. Page 4 of my lord notice of motion.
Yes.
Injunction restraining respondent number 1, me, from receiving lease rental from respondent number 4.
Yes.
Injunction restraining respondent number 1 from acting contrary to the terms of the agreement dated 30th January 2020 and in making any demand without first giving credit to all sums received from respondent number 4. Matlab again demand. Then C, injunction directing the respondent number 1 to make over to the petitioner number 1 the title deeds in respect of the property situated in the Mauja, Dhalenda, jail number 8, in respect of RS Dag number 65, RS Dag number 66, RS Dag number 67. Matlab, pausing for a moment. Your lordship be pleased to come to their application in volume, volume 2, their interlocutory applications, my lord, the main letter of understanding or memorandum of understanding. It starts from, my lord, page 197.
Yes. Yes.
Letter of understanding dated, my lord, 15 January 2020.
Yes.
My lord, borrower number 1, yes. Mohan Motors Distributors Private Limited, in liquidation. Mohan Motors Udyog Private Limited, in liquidation. Mohan Motors Services Private Limited, borrower 3. And my lord, Mohan Motors Sales Private Limited. My lord, left hand portion is, my lord, illegible. But my copy is like that.
Where from you're reading?
Page 199.
Yes.
Starts from, my lord, 198.
Yes. First 2 are the borrowers,
yes.
second 2 are the 3 are the 4 are the guarantors.
Yes, my lord.
And the
5 companies are borrower, and subsequent, my lord, the parties are, my lord, guarantors, up to guarantor 10. And your lordship sees that guarantor number 1 is the plaintiff, who rendered guarantee for borrower number 1, that is the company in liquidation.
Yes.
And subsequent company, my lord, which is in liquidations, and for, my lord, the other companies. So, my lord, guarantor number 1 stood as overall guarantor for all the borrowers. And apart from, my lord, the plaintiff, petitioner number 1.
Why you are telling that the guarantor number 1 is the guarantor for all?
My lord, it states that, my lord, he is a guarantor number 1.
Yes, one guarantor.
Yes.
There are altogether
Other guarantors, my lord. Other guarantors are there. But, my lord, positions of that, my lord, person, he stood as guarantors.
Correct.
Along, my lord, respondent number guarantor number 1, guarantor number 2, 3, 4 are all guarantors.
Correct.
Guarantors for, my lord, the borrowers.
Correct.
Yes. So, my lord, the guarantor number 1 also stood as guarantor for the companies who are in liquidation. Apart from, my lord, guarantor number 1, other guarantors also there. But since, my lord, the plaintiff has approached before your lordship, my lord, he says, my lord, I'm asking for discharge. So, my lord, the issue is not very plain and simple, my lord. He is also guarantor. And the company has, my lord, mortgaged all the properties in favor of respondent number 1, not only to discharge his liability, for discharging liabilities for other borrowers also. Now, my lord, my subsequent point is that, your lordship, this letter of understanding, my lord, was made in respect of a total outstanding which comes page minus 203. My lord, when at that point of time, my lord, it was executed, the claim amount was 27 crores 87 lakhs 31,345.
Yes.
Out of, my lord, total loan responsibility of 51 crores and odds.
Yes.
And the arrangement through this letter of understanding was made that a subsequent payment will be made, my lord, that is followed by, my lord, paragraph 10, that page 205, that the guarantor number 1 and 3 approach KMPL, that's, my lord, me.
Where?
My lord, page 205,
Yes.
paragraph 10.
Yes, KMPL.
The guarantors number 1 and 3 have approached KMPL and requested KMPL to provide consent to lease out immovable properties, more particularly mentioned in Schedule 2, property number 1 and 2. So, my lord, the schedule portion of this letter of understanding, my lord, is, my lord, stated in page 212.
Yes.
Property number 1, all those office block number 1 on the ground floor measuring 741 square feet. 2, office block number 2 on ground floor measuring 1150 square feet. 3, office block number 3 of the ground floor measuring 963 square feet building and constructed upon land measuring 17 kattha, 2 chitaks, 16 square feet. Presently known and number and municipal premises number 55 and 55-1, Chourangi Road, Police Station, Shakespeare Soroni, with the limits of Kolkata Municipal Corporation. And, my lord, subsequent one, next page 213.
Yes.
Saliland measuring 17 katthas, lying and situated at Mouja Dhalenda.
Yes.
PS Tiljola, RS Dag number 50. So, my lord, as per this letter of understanding, the properties which are involved with this letter of understanding is, my lord, a property which is situated at Chourangi Place and a property of Sali land measuring an area of 17 kattha, situated in Mouja Dhalenda with RS Dag number 50. Lordship kindly compared, my lord, this portion with, my lord, the injunction applications prayer portion, that is, my lord, prayer C. That is, my lord, the notice of motion, page 5, my lord, rightly what I've shown, my lord.
Yes.
Injunction directing the respondent number 1 to make over to petitioner number 1 title deed in respect of property situated at Mouja Dhalenda. Lordship, be pleased to, my lord, to compare, my lord, this schedule portion with, my lord, their prayer. So, my lord, I'm comparing, my lord, their prayer portion with, my lord, page 212. RS Dag number 65, Khatian number 519, 521, 522, RS Dag number 66, Khatian number 180, RS Dag number 67, Khatian number, ward number 58, 105, Kolkata. So, my lord, the property.
Where from you read?
My lord, page 5, notice of motion, my lord.
Correct. The C injunction.
C portion.
Correct.
Injunction.
Correct.
Directing
Now,
the.
where from this, the page number 212?
Yes, 212, my lord, is, my lord, the area.
Where is that?
Yes. Schedule 2. Schedule 2, page 212. Schedule 2. On those office block number 1, measuring 741 square feet. Then 2, office block measuring 1150 square feet. Then 3, 963 square feet of Chourungi. And, my lord, the property, next page, 213, covers the area 213. My next page, my lord.
Correct. I am going.
My lord, RS Dag number 50.
Correct.
So, the property, my lord, which belongs to, my lord, RS Dag number 50, and, my lord, the area which belongs to, my lord, Chourungi Road, my lord, that is, my lord, the subject matter of, my lord, this letter of understanding.
Correct.
But prayer is made asking for releasing of the properties.
So your main contention is that the description of the property mentioned in prayer C is not the property in the understanding. That is your question.
Yes, my lord. So, my lord, this is my first point. Then, your lordship, be pleased to take up once, my lord, the page 205. Each and everything of the suit is, my lord, targeted on, my lord, letter of understanding. So, my learned senior friend, my lord, has expressed this in accordance with his expression, my lord. I am reading, my lord, what is written over here. Then, my lord, again, my lord, coming to the guarantors number 1 and 3 approach the KMPL and requested KMPL to provide consent to lease out immovable property, particularly mentioned in Schedule 2, 1 and 2, Annex Heir 2 to Nerbelam Leasing Company Private Limited for a period of 99 months. So, my lord, this letter of understanding, my lord, will continue for a period of 99 months. That is, my lord, 8.3 years. And the date of commencement is, my lord, 2020. So, approximately, my lord, the tenure will end, my lord, between, my lord, March or April 2028. So, my lord, that is why, my lord, still, my lord, this letter of understanding is subsisting between the parties, and the Nerberam is, my lord, making payment through, my lord, escrow account to my client to respondent number 1. Further agreed and provide consent to appropriate the monthly rental. My lord, I am reading, my lord, further. Apart from, my lord, 99 months payable, further it was agreed and provided consent to appropriate the monthly rental, maintenance facility charges receivable towards part payment. So, my lord, this arrangement was purely made on the basis of making part payment. As per this arrangement, the money is supposed to come 12 crores and odd. And, my lord, the agreement states that he is liable to make payment as on 2020 the amount is 27 crores. So if, my lord, we deduct, my lord, 27 crores from, my lord, total receivable as per, my lord, this letter of understanding, a sum of rupees, my lord, 15 crores and odds, my lord, is due and payable. So that is why, my lord, this letter of understanding states that apart from monthly rentals, maintenance facility charges, receivable towards part payment of outstanding amount, dues and payable to KMPL under financial facilities. So, my lord, this financial facility, subsequent, my lord, letter of understanding, construed, reason being one various finance facility was availed by plaintiffs and defendants, the parties herein. And as, my lord, the parties to this proceedings, my lord, failed to make payment, I initiate a proceeding under section 13(2), and against of which, my lord, this arrangement, my lord, has arrived. And it is, my lord, part settlement.
But if we come to the 6,
my lord,
204,
yes, my lord,
read the 5 and 6.
Yes, my lord.
What the 6 says.
My lord.
After signing of this letter of understanding, the statutory notice issued through the letter dated so under the surfaces shall be kept in abeyance till the pendency of the present.
Yes, my lord.
If you're telling that it is pending, so why you're issuing the notice?
My lord, letter of understanding is in respect of the property which is mentioned in Schedule 2. And it should be kept in abeyance in respect of, my lord, Schedule 2. Arrangement is for, my lord, 12 crores. And 15 crores and odds, which, my lord, the appellant, petitioners and plaintiffs are supposed to pay. My lord, that is required to be paid either in accordance with the agreement, and if they fails, my lord, I can initiate a proceedings in accordance with law.
Show where is that your submission contains this undertaking clause. Show me
Yes,
that.
yes. That's why, my lord, I read, my lord.
Show the clause.
Yes, 10. 10, my
What is
lord.
the clause that you can continue after the clause 6?
My lord, 10 says that.
What?
10. My lord, may I read once, my lord? Guarantor number 1 and 3 approached KMPL and requested KMPL to provide consent to lease out immovable property, more particularly mentioned Schedule 2, Property 1 and 2, Annex here to Norvelum Leasing Private Limited for a period of 99, and further agreed to provide consent to appropriate the monthly rent, maintenance, facility charges receivable towards part payment of outstanding amount due and payable to KMPL under financial facilities.
Correct.
Then, my lord, if your lordship sees page 208.
Yes. Yes.
11 portion. Please take further note that this letter is only conditional permission for lease of the said property mortgage with KMPL, and KMPL shall continue its mortgage right or any other security rights on all secured asset secured until entire outstanding amount is receivable by KMPL.
Correct.
So, my lord, this is talking about not, my lord, 12 crores. It is, my lord, about, my lord, entire settlement amount that is derived, my lord, 27 crores. So, apart from this, my clients has every right to ask for the amount which is due and payable by the borrowers and guarantors in accordance with law. And, my lord, this one, what I state, it supports my letter of demand that is issued in the year 2024.
The two companies who are under the liquidation,
Yes,
can
my
you
lord.
put the burden of the other party?
My lord, a person who is in liquidation, my lord, I cannot make claim.
Then,
but my lord,
if leave aside that, so what is the claim of this other person?
My lord, but respondent petitioner number 1, that is the plaintiff, has executed guarantee.
But you can't. Even I have guarantee whether the company is in liquidation. Can you say you are the guarantee? Leave the company and I will recover from you.
No, my lord, subject to correction, my lord. I am, my lord, covered by my lord judgment that amount can be made, can be
The company is liquidation.
from
My lord, section 128 of the Contract Act, only upon default, not otherwise. Which
my lord, in this case, my lord, my line of argument is, my lord, suit
See,
is
with
filed by
you-
my lord guarantor.
You are arguing mainly on this prayer C.
My lord.
I am telling the prayer C, I am not concerned with that.
My lord.
Correct.
My lord.
With regard to the claim, you answer to that.
My lord.
I am not releasing any property at present.
My lord.
I am telling here in now in the open court. I am not in with it is the lease period is there.
My lord.
That is to be decided. With
My
regard to the what about the notice you are claiming the amount, what about that?
So, my lord, what is my contention? If your lordship is that, my lord, the notice portion, what I have claimed, against of which, my lord, they have moved before my lord DRT. So, my lord, the claim amount which I have made, rightly or wrongly, my lord, that is at that juncture, my lord, pending, my lord, for adjudication before debt recovery tribunals.
So if it is pending, why you issued the notice fresh?
No, my lord. After issuance of my notice, my lord, they preferred an application under section 17 before, my lord, debt recovery tribunal. It is not that my claim was there, then subsequently I made a claim. So soon I made a claim.
There is a section notice
Yes.
Section 17 application.
My lord, section, my lord, my landed friend also admitted that they have preferred an appeal.
Where is that?
My lord,
Your bank.
My lord, it's not, my lord, with me, my lord. My lord, if
you have made out a case that they have preferred an appeal. Where is if
they have already preferred an appeal. The matter is pending.
Yes, Mr. Bose, you have prepared an appeal.
My lord, we have challenged the steps taken by them under section 13(4). So they have taken steps to enforce the security. So for against which, my lord, your lordship is aware, my lord, an appeal provision is there, statutory right of appeal under 17. So that is different. Here we are seeking enforcement of the settlement agreement. So our respectful submission is confined to only the fact under the settlement agreement, they have recovered more than what is due. And another limited submission is that two companies, which my learned friend has rightly admitted, is in liquidation. They cannot claim in respect of those two companies. Your lordship is right. We have deducted that amount. So what is left? So they have already collected through the lease rentals from the third party much in excess of that. So how are they proceeding to collect and adjust the proceeds from the lease rental from the outstanding dues, because there is no further outstanding due. The debt, so far as my debt is concerned, entirely stands discharged. So where is the question of invocation of guarantee? Because I'm a guarantor. So unless the borrower is in default, you cannot invoke the guarantee under
Lord, may I
section
show how the
128.
borrower is?
Yes, continue. Yes.
Mr. Banerjee is also appearing, my lord. My lord.
My lord, first of all, I don't know, my lord, whether my junior has taken the point of maintainability of this petition or the suit before, my
As of
lord.
now, I'm not.
No, he is
My lord,
arguing.
firstly,
He is arguing on merit. There is no mentality.
no, not required. There's no requirement for looking into the merits at all, my lord. Not required at all.
For the last 1 hour, he is arguing on the merit only.
My lord, I'm very sorry to say, but my lord,
It's very unfortunate. One advocate is coming arguing the merit, and second advocate is coming on the mentality. What the court will do?
I'm very sorry for that, my lord. He shouldn't have, my lord, argued on the merits at all.
This 1 hour time.
My lord, all that I can say that, my lord.
Problem here. One junior is coming, he arguing the matter, then senior will come and he will again start the matter, then the matter never ends. and
My lord, on a
subsequently
my lord,
when the court is having the total burden, then you praying for them. There is an urgency. Fix the date and time.
my lord, may I
Last
say
1
on
hour
a
is
light?
he has not argued the matter. Otherwise, I could have been tell that you argue the matter on maintainability. He has not argued the matter on maintainability. He has started the total on facts.
My
I
lord,
think
on a lighter note, may I say this, my lord, since it is an Friday afternoon, that my lord, for the respondent in this matter, I will only take, my lord, 20 minutes. Although, my lord, this has been argued by the plaintiff at least for 4 days.
yes,
So, my lord, gives me that.
See,
That
with
gives
regard
me
to
that
giving
20
the time does
minutes.
not arise. But if you're taking the mental,
Sometimes juniors make a.
that is
I
to be
appreciate. Sometimes juniors make a mistake, my lord. I'll only take 20 minutes by the clock, my lord. I have heard 4 days. I'll take 20 minutes by the clock, and the dates that were fixed, my lord. This matter, my lord, at least we have not taken any adjournment. Now, my lord, kindly sees, my lord, this transaction, whatever transaction it is, good, bad, indifferent, whatever it is, it's a commercial transaction. Why I say so, my lord, kindly takes the agreement. The agreement is a finance agreement. And my lord, kindly takes, my lord, the Commercial Courts Act and kindly takes, my lord, section 2C. The plaint has to be rejected in the form of Order 7, Rule 11.
Yes.
My lord, kindly takes 2C. Commercial dispute means a dispute arising out of ordinary transactions of merchant, bankers, financiers.
Yes.
So, my lord, this cannot be disputed that this is a financial agreement.
Yes.
Now, my lord, will kindly see this is a suit which has been admittedly filed in 2024.
Yes.
They tried to obtain an ex parte interim order. Lordship refused it. Lordship, they went up before the division bench. Division bench interfered to the extent to this only that till the matter is heard out, the, my lord, protection should be there given to them. That is all. Nothing more than not on merits, my lord. So therefore, my lord, if this is a financial agreement, then in 2024, my learned friend could not have filed this suit in the ordinary division.
Yes.
So I don't want to get into the merits at all. Now, my lord, in 2023 October, the rules of this honorable court with regard to commercial filing has come in. Now, Lordship, I think my junior is there. He will hand over the rules to my lord. Lordship will kindly see Rule 4 and 8, which clearly says Lordship cannot transfer it. Lordship has to dismiss it. Lordship has no right to transfer it to the other division. Lordship has to dismiss it. Now, my lord, I am relying on my lord's own judgment, which was, my lord, passed by my lord a few days back, which I have relied in other matters also. I think my junior will hand it over. Lordship has held in, my lord, the judgment itself that, my lord, if a suit is filed, which is to be filed in a commercial division and is being filed here without leave under 12A to scuttle that, my lord, that has to be rejected under Order 7, Rule 11 procedure. So, my lord, I am on the fundamental issue. I will not make submissions on merit. That, my lord, how could they file a suit before my lord, in this division?
Yes.
On merits, I have a fantastic case, but I don't want to get into the merits. First, my lord, the issue is that, and I have not taken 20 minutes, my lord. The suit itself is not maintainable.
Okay.
And
That's
it
all.
cannot be transferred. Yes, my lord, and it cannot be transferred. So the suit has to be dismissed. Interim order has to be vacated. Thereafter, whatever he does, he will, my lord. On the merits, my lord, I will only make submissions once he is able to scuttle out this, my lord, provision as to how he has filed a commercial suit under this ordinary division and tried and obtained an order or had from the appeal court itself. And, my lord, I can take the point of maintainability because I am for the first time coming before my lord. In the appeal court, we went. My lord, the appeal court has only, my lord, only directed it to appear before my lord. So the suit itself on the face of it is not maintainable. That is all, my lord. Thereafter, I'll make submissions. If your lordship holds against me, I will, my lord, thereafter make submissions, my lord, on the merits, my lord, which, my lord, I have a very good case also. First of all, my lord, it is not maintainable before my lord in this division. And lordship rightly did not pass an interim order at the first instance, and now lordship should dismiss the suit itself. under Order 7 Rule 11.
Yes.
It's barred under the law.
Yes, Mr. Bose.
My lord, your lordship recollects, my lord, there was a matter where Durgapur Ispat versus Central Bank of India. Well, it was your lordship's judgment your lordship held. There, my lord, it is not a commercial suit. And thereafter, my lord, it went before the regular division. My lord, the contrary argument today has been made. My lord, where extensive arguments have been made, my lord, there was a judgment of the division bench of presided by Justice Harish Tandon, which we relied upon spice of joy. Spice of joy. My lord, what my learned friend had, at this stage, after my final arguments are complete, and he has to address your lordship, my lord, he comes and says that this is not a regular suit, but a commercial suit. Now, the question is that he can take the point of minority, I don't say. Well, now that today, my lord, instead of, my lord, ad interim order was refused on the ground of section 34 of the SURFACE Act. Your lordship was of the view, while refusing the interim order, that the suit may be barred by section 34. That was your lordship's prima facie view. Appeal, thereafter we are back with the interim order, exchange of affidavits has been argued. Well, I'll still address this issue. My lord, if your lordship will see the definition, 2C definition, it says what? My lord, ordinary transaction of bankers. And my lord, kindly have a look at the relief that we claim in the suit. My relief is confined to the settlement agreement. So at the moment I say my relief is confined to the settlement agreement and I seek specific performance of the settlement agreement. And my lord, if I would have filed a commercial suit, my lord, that suit would have been before a court without jurisdiction if I had filed a suit for commercial dispute.
No.
Kindly see the definition of 2C.
Specific performance of what?
Of the settlement agreement.
This is the page. Correct.
If you,
So that is called the financial agreement.
no, my lord, it is not. If your lordship will kindly have a look at that agreement.
Letter of understanding.
It is a letter of understanding.
Correct.
My lord, I lordship will pardon me, my lord. I am on the virtual platform, my lord. I thought today they will argue, so my lord, I don't have the brief with me. But based on my recollections, my lord, I will try and assist your lordship.
197.
Yes, my lord.
197. The letter of
Yes.
understanding. So you want for the specific performance of this.
Correct. Absolutely, my lord. Now, my lord, apropos this, my lord, kindly have a look at the definition. Kindly see Roman 1 of 21C.
Yes.
Ordinary transaction of merchants, bankers. So we'll stop here. So is it an ordinary transaction of bankers? Do bankers enter into this kind of letter of understanding in their usual course of business? They don't. So what they do is they lend money, they give fixed deposits, they give project finance, they do other things which are otherwise a bank is competent to do in its usual course of business. So this is not their usual course of, not an ordinary transaction of commerce. So this is a situation where 5 loan accounts were settled by one letter of understanding. So my lord, this letter of understanding is my cause of action, subject matter of the suit and relief. And nothing more. Lordship, you kindly have a look at the reliefs that I seek, my cause of action, by the averments made in the plaint, all confined to the letter of understanding. So my lord, the moment I file a suit, which is a letter of understanding, then my lord, now if your lordship, also I need to show your lordship some of the paragraphs of Ambalal Sarabai.
That's why if you come to the this understanding.
Yes, my lord.
Bank, kindly come to the page number, page 203, paragraph 2. The
My lord.
facilities were secured by way of first exchange.
Correct, my lord.
So this is the financial transaction between you.
Yes, yes.
The bank.
So I am not questioning any of those financial transactions. I accept all of those financial transactions. But there was a subsequent agreement which superseded the financial transactions, which is the letter of undertaking. And so, well, this letter of understanding is a independent contract between the parties, a valid independent contract within the meaning of the provisions of the Contract Act. So, well, if that is a contract for of which I seek specific performance, would that contract be an ordinary transaction of a banker or not? This is the issue.
Yes.
So, well, allow me to come back on this issue. I will just give you a lot.
Well, may I just give a reply to this in 2
So
seconds?
here,
May I give a reply to this?
My respectful submission before your lordship is that.
Let Mr. Bose complete, then we'll come to that.
Well, my limited submission is that at this stage, your lordship should not allow my learned friend appearing on behalf of the respondent defendants to take this point of commercial dispute. It was not taken at the threshold because I'll tell you, lordship, there's no rejection of plaint application. He says that the plaint deserves to be rejected. So on what basis will it be rejected? At best, my lord, with respect, my lord, as far as I recollect, there is no such specific case made out by them in the opposition also, that this is not a commercial. I'll stand corrected. Well, there is no specific case made out in their opposition to my interlocutory application by which they say that this is not a commercial suit made in the meaning of 21C. So today, at the final hearing of the interlocutory application, you come and say the interlocutory, this is not a commercial dispute. No case, no application taken on nothing. No point taken also at any point of time. The matter has been heard on repeated occasions. Before I started, post the appeal court's order, when we started, they could have taken the point. I would have addressed this
Well,
issue
I
at the
think
threshold.
Mr. Bose has forgotten. I had said that the application is not maintainable. Suit is not
What do you mean by
maintainable
the
on the first
application?
day.
You are saying today, you are saying that the suit is
the
not
suit-
maintainable, not
yes,
the application.
Yes, I said the suit is not maintainable at the first.
With
I said
respect,
at
my
the
lord,
first day.
if it is not maintainable, you should have addressed. Once you take the point
No,
of
no,
maintainability, that
is
has
up
to be
to my
decided
lord.
first.
That is up. The point of maintainability can be taken at the SLP stage also.
Of course
law
you
is well
can. Of course
settled.
you can. How will
I
you
can
take
understand it.
File an application, it will be decided.
I don't need, my lord. I'll argue that. I don't need
Then
for
come
a
and
point
argue
of
that.
law. I'm
Come and
arguing
argue
it.
that.
I'm arguing it today. I'm not taking
Your
an adjournment.
junior addresses the matters on merit for 30 minutes.
Mr. Bose
And then you come and take the interlocutory point and then you say, very well, I will also address the... I am not shying away. I will also address the point of maintainability.
Juniors in between, my lord. My lord, may I just reply this, my lord?
No, there's no reply. I haven't got. If you raise the point, well, the point has to be replied, suitably replied.
I thought Mr. Bose was replying to it.
Yes, I am replying. I have much more to
adjournment.
reply. Because if today, my lord, if your lordship is appreciating the point of maintainability of whether it is a commercial suit or an ordinary suit, well, kindly, my lord, give me one opportunity. Well, because today I'm totally handicapped. I'm on the virtual platform. I don't have my brief because today.
Just now, Mr. Bose was complaining about my junior.
Maintainability, full stop. Counsel for the plaintiff has argued time and prays for time to give proper reply to the question of maintainability. Let the matter appear on 19th September 22.
19th September.
19th
My
September.
lord, lordship is fixing a time, my lord. Kindly, my lord.
The two. It
will
will
be in the first. Maybe in the first half, my lord.
My lord, could it be on any other day except 19th? Any day except 19th.
19 and then 26.
26th. That's the last day of the court.
I'm agreeable, my lord.
These are the only 2 days.
Will come for this matter.
Before
Yes.
vacation,
26 will come for this matter in the. But would it be in the morning itself, my lord, so that we can leave?
Morning can't.
My lord, 19th, my lord, kindly take my lord 22nd, 23rd, 24th, any day, my lord.
On commercial, I can't take, and other later times are already fixed as other matters. So
Then very well, my lord, keep it on the 19th. Keep it on the 19th, my lord. Okay, because it will be taken up in the second half. So my lord kindly keeps it on the 19th.
My lord, can it be in the first half, my lord?
Mr. Banerjee,
My lord, can it be in the...
All my matters are fixed on.
Yes, my lord. Kindly keep it in the second up
we
at 3
come,
o'clock.
My lord, at 3 o'clock, my lord, can we come back at 3 o'clock then, my lord? That is exactly
Yes,
what I
yes,
was
3
saying.
o'clock. 3 o'clock. 3 o'clock. Very well.
Great,
Deeply
grateful,
obliged.
grateful,
Grateful.
grateful.
Grateful, my lord.
Item number 39, my lord, the interim order is expiring.
Where is the order? Who is for other side?
My lord, I am for her side.
No, no,
Lordship 34. I'm led
Oh,
by
34. 34. Sorry, sir. 34. 34, my lord, we have put them on notice. There is a subsisting interim order which has been continued by your lordship from time to time.
Interim item number 34. Counsel for the plaintiff press for actions on the interim.
my lordship. I'm for the defendants.
Yes.
Yes.
Ready?
My lordship, I am appearing. I am asking for an. Today I mentioned the matter. I'm led by Mr. Choyan Gupta. He's not.
I am extending the interim order.
I'll
Press for action.
oblige, my lordship.
Interim order is extended. Let the matter appear on 7th November.
Lordship, time may be fixed.
7th November. Interim order is extended. लिखा ना? 7th November, let the matter appear on 7th
Grateful. Grateful, my lord.
My lord, I have similar prayer for item number 39, my lord.
That is the order.
My lord, I'm sorry, I have just a soft.
39 part heard?
Yes, my lord.
Which matter?
My lord, this is a defamation suit, my lord. My lord had passed orders directing them not to carry out any
39,
further.
Counsel for the petition press for actions on the interim order. Interim order is extended till 7th November 2025. This is the matter on 7th November.
My lord,
My lord has extended it.
7th November.
I'm so grateful.
my lord, seeking your indulgence in respect of item 38, I appear for the plaintiff. So the demurrer application was being heard. The urgency is that this suit has been continuing and we have an injunction application that's pending, which is GA3. So unless GA1 is decided, we cannot press our GA3, which is our injunction application. So it is appearing in today's list. So I was just urging if your lordship could fix
Yes,
the
I am
date
ready.
as per your convenience.
Come, ready. I am ready.
My lord is rising. I have no difficulty.
I will not rise. I am ready. You persons allowing me to go. Otherwise, I am ready. You ready? Come.
Lord,
Otherwise, go. Come after the vacation.
Any day, if it could be fixed after the vacation, subject to your lordship's convenience.
Give the date. December 25, 24.
Lord, could it be in November?
November, there is no date.
My lord, then in that event, I have further prayer for time could be.
22nd November is dairy permits.
My lord, I have no difficulty. If a time could be allotted for the matter.
That's it. You want the time, then I will give the time and date on 22nd November at December at 2
My
p.m.
lord, December. My lord, November kindly accommodates in November. Kindly accommodates the matter in November. December will be very far-fetched.
So let it be remain in the list. When you get it today, you are getting time. You are not arguing the matter. What can
Lord, I have no difficulty.
so argue? Court is here. I am here. You argue. Is there is an urgency?
My lord, actually, I have no difficulty placing my matter, but the GA1 was being argued by Mr. Ray. He's the defendant in this matter, and he had taken out his demurrer on the ground of Section 8 that the subject matter is covered by an arbitration agreement. So we had argued the matter. Both Mr. Ray had argued, and also I had argued the matter. But he was supposed to cite some judgments, and since then the matter has not been taken up or has been adjourned.
What can be? Let it be remain in the list. You try your luck. Yes, next.
Very well, your lordship. Grateful.
Item number 42. This is Mr. Dotto is there on my other side. Now there's some typographical error in my lord's judgment. The name I mentioned the matter. That Lordship was pleasure to make a formal application. So that's the only application. Whether I move it today or I'm ready to move.
Other side is ready. Then I will take no problem.
Yes, I am ready to move.
My lord will kindly
Name correction.
Name correction, not simply a name correction, my lord. My lord will kindly peruse the records, my lord.
May I place my application?
Subject to correction, my lord, the affidavit which was filed by this lady, she has written this spelling only. My lord has proceeded on that. My lord can see the original records once.
I have annexed.
And the cost
Item
title also bears the same said name. my lord.
Probate application.
Kindly see that affidavit.
May I place my application first?
Yeah, you can place, but
You can
I
take
have
because
just,
he is
my lord
the-
asked me, that's why I have.
He's taking the
Okay,
responsibility.
let Mr. Datta, 42.
He's taking your
I'm not
responsibility.
actually good. What is dog yard?
Where is your plaint?
Page 9. Page 8, page 9. The
MANT you want to
no, yes, the page 12. Page 9 at page 12. The first name is SOVA.
SOVA.
Shova. So that is the plaint.
Ah.
Now in the affidavit in support of caveat, I have annexed. I'm not suppressing that also. In the affidavit of support
You
of
are
caveat,
appearing for whom?
Shobha.
You are appearing for
Shobha was the caveator, the lone caveator, I contested.
Correct.
Probate, whatever. Now, my lord, in the affidavit in support of caveat,
Where is that?
This is there's a
23. 23.
So Pina, page 23 is my lord's judgment.
Shobha.
Shobha. So it's gone down as Shobha.
That is affidavit.
Yes.
The
Kaun
caveat.
constable?
Page 23.
Page 23 is the affidavit in support of caveat.
Their affidavit.
Yes.
Your affidavit in support of caveat.
Page 23 হয়ে গেল আপনার ওটা page 23 তো আলাদা দেখছি Lord, you will see. Whatever. Yes, I have also done the affidavit the same.
SOVA JUPTA Gupta.
And
Yes.
SOVA, their problem is SOVA. They have stated in their own affidavit.
Yes, I have stated.
SOVA, SOVA. My lord has also proceeded on the basis of that affidavit.
I'm not on that. It is my lord's mistake.
SOVA is in the caveat also. SOVA is in your application also.
Yes.
Private application.
Yes.
That's
So, yes.
That's
So
there.
now what is the name?
Yes, Lordship, I have annexed my Aadhaar card also. Lordship, this also there's also folded my Aadhaar card. What happens, my lord? My client signs in Hindi. So when the caveat was filed, it may not be of that a strict a proceeding around 10 years back. So we signed in Hindi Sobha. কোথায় লাগালাম তো আধার কার্ডটা I have annexed my Aadhaar or the
Where is the Aadhaar card?
May I fold করে রেখেছি it's folded man page 20 না না আরেকটা
अरे उसका ना उसमें लगा
page 29 এসছে yes page 29 is my voter card my lord, which is this is the name now
page 29
yes page 29 is the name and lordship will kindly yes. Now, what's the difficulty I am facing, my lord? In the affidavit in support of caveat, if the original is there, my lord, should we say I have signed in Hindi. So the spelling was never a problem, and this was signed in the year 2015. I don't know, the different advocate was there. Now, department, I'm not blaming anybody. Now, I want to file an appeal. That's why what's troubling me, my lord. Otherwise, the decree is there, whatever is. When I went into filing an appeal, when I went to the affirmation, I have to show my identity card. All my identity card is SOBHA. And the spelling is SOVA. The department is not accepting with this identity card SOBHA. That's my problem.
Tell me one thing. Here in the original side, you are applying with a certified copy with the full address.
Full cost.
Okay.
Full cost. So the full cost title is there. The spelling. So then the department not accepting the affirmation. That's my problem. That is the reason I mentioned the matter before the division bench.
No, it is so SOVA is already there.
No, but I want to change it SOBHA. So you will see my prayers in the master summon, recording the name of the defendant as Shobha. See the master summon prayer.
Shobha Gupta.
Yes, in place and state of Shobha. So that's the pronunciation or that the problem. It is not a different person. Yes, this is the thing. Or it make it alias. Unless this is done, I cannot file an appeal. I mentioned them with the appeal code. Appeal code says the typo 150. Go to 152, no? 152. And appeal code. I came back to your lordship. My lord's view was formal application, but the decree has to be corrected accordingly. So that's the application.
So
now,
what do you want to correct?
No, I want to correct this name. Now, lordship will kindly come to my lord's decree, which is at page 31.
Correct.
This is Pradeep Kumar Benia versus Shobha Gupta.
Correct.
This is SOBHA has to be, or lordship will as alias. So then I can't file an appeal.
But in the Affidavit in support, so.
She will see at page 30.
And in there.
Yes, it is there. That came from their plaint. The problem started. No. Plaint was first. My affidavit was not the first document.
My simple point of objection, I may be making a mistake. When they have affirmed this affidavit which is appearing at page 23, the lady has disclosed the name as Shobha, S-O-V-A.
इसका original file है क्या? नहीं है. Original file नहीं है.
The difficulty is the Hindi.
No, in the original, what you have signed?
Hindi.
Shobha or Soha? In the affidavit.
No. Lordship
affidavit in support of caveat.
Yes. Let it be produced.
The Lordship is on the Hindi spelling also. Let it be produced.
That is the only thing. If you have signed the affidavit in support of caveat as Shobha Gupta, not Soha Gupta, correct? But in English it is recorded as Soha Gupta, then it can be done. Because now in the appeal and in all this, you are telling that Shobha.
No, I have also annexed my Aadhaar and
Aadhaar card.
Yes.
Shobha Gupta.
This is a disclosure which has been given by you.
Because he is taking the time what you are discussing, because the sign affidavit of caveat is not before this.
Not signed. So not the annexed copy is not the signed copy. As far I have seen is
I'm not good in Hindi.
I don't know.
Applicant has filed. Applicant
Bangla আমি একটু ভালো.
The petitioner, Shova, S-O-V-A, Shova Gupta, has filed the present application being GA4 of 2025 in TS 20 of 2016, praying for a direction, praying for correction of her name in the cause title of the plaint as well as in the judgment and other documents as Shobha, S-O-B-H-A, Shobha Gupta instead of Soha Gupta, S-O-V-A, Soha Gupta. Instead of S-O-V-A, Soha Gupta. S-O-B-H-A, Shobha, S-O-V-A, Soha Gupta. Full stop. Learned counsel appearing for the executrix, for the testatrix, executrix or executor.
I am the executor.
Executor.
Yes.
Counsel for the executor / plaintiff raised an objection that the affidavit in support of caveat is also filed by the petition by the applicant / caveatrix in the name of Seva Gupta. S-O-V-A, Seva Gupta.
Only one. Sorry, but you will see in paragraph page 23, though it starts with SOVA, a purpose, my identity card is annexed.
Okay.
This identity card is
and the counsel for the caveatrix submit that the Aadhaar card and the election identity card also reveals that the name of the applicant is Shobha, S-O-B-H-A, Shobha Gupta instead of Soha Gupta. To ascertain whether in the affidavit in the affidavit in support of caveat, whether the petitioner, whether the applicant / caveatrix has filed the same, has signed the same as Soha Gupta or Shobha Gupta, let the record of title suit number 20 of 2016 along with the affidavit in support of caveat filed by the caveatrix be placed before this court on the next date fixed. Let the matter appear on 19th.
But with some precedent.
19th.
19th is the day of my lord. If it is 3:30, if it is below in the list,
as item number 2.
Deeply obliged. It has to be worked out by me.